try. You can't promise that yet. The meat, guaranteed, but you can't promise the forks and all that crap. Some will pack to come in and say you tried it. But I gotta get on Quirtle games, you know, I do that. I gotta get tables.
You're ready to start loading stuff up, call me, I'll have a
Yes,
truck
and
up there and
Johnny's
run
is there.
around.
We get tables for our house.
We'll
Okay.
do whatever we need to do.
Okay. And by the way, I do that shit Friday, so I'm trying to do it all Saturday morning early, huh?
That's fine.
Okay.
Now I'll just tell Brooke or somebody else that we're gonna help us. Get you some beer.
What you call the tables is over far house. I mean, yeah. My mother already told me, tell them you get all the tables you guys need. Yeah, you know, corn old
We
turtles.
got quite a few tables over there too.
Right, we need to put round tables. We need old square tables. We need, I would have put the food back in the other hall, we'll put the food in the back, but that back door, the man sit in the corner. You know. And as you come in that one door, put another long table there people sit at. That way you got more seating in because in front there where the van is, we can open up and people dance a little bit, you know. Come up, put corners in the back, people have something to do. Just sitting around. We're going to turn it back here. We're going to turn it 20, 40, I mean 28. That's easy to run that. I know right now. Every time that's fine. Cool gift card, $25 gift card. We sell 50 of them, make $20 for each one of them. They go like hotcakes around that time of year. I gotta get a hold of Brenda, see how to get some pull tabs. There's some 50 pull tabs, you know, and some of them hour change. $20 gift card, make $50 on it, you know. So that right now, I already got a stack of more prizes already. Gift coming out, gift cards, man, like I got for the image salon, give me $50 gift card, just like there, and I got a whole stack of them like that, man, got it ready. So Sarah today, I said, you know what? Sorry, help me.
People are willing to do things.
Yeah, they dropped off the leash. Her name is Sandy. I don't know either, they said Sandy. People she are out there. I'm like, you know, what's Sandy who? They say, we know Sandy. They have my name on it, make sure you have noted this. This is for a NOPSA benefit. I don't know about that. Whoever it is, they know us, put it that way. They know us, they know him, that's all you know that. But they went around and got these for people for us, so they know us, know him, us, and the other program going. I know say, I'm sure when I have you in here, she might come to me and say, you get those cards down to who he is. I know a lot of Sandys. I want to think of Sandy Martini, but I'm not sure. I made her talk about it once, but not as far as it went. American Indians, but she's going to tell them it's a beat down here. They're always been children.
Been there.
What do you got, buddy? How you been, man? Pretty good today. How's life treating you? So, we're looking at you living. I keep saying I'm looking down that I ain't too bad so retired though, you know.
You know what that's doing.
Well, I suppose
My wife died. You probably won't appreciate it. That's what
I still get some things. Fast enough up for me.
that's bad. In about 2 minutes, I think I closed it now.
Where at? We didn't know this, is he? Where that ball is, the mayor. It's not like, just
Water?
Don, are you going downstairs?
no, it ain't.
You, what?
Downstairs?
I'm gonna check.
There's
See.
not any.
This is city.
I was going to ask you anything good. So far, so good.
You know, I haven't seen you in a while.
busy day.
No, it's all taken care of.
Oh, good.
I'm sorry.
Over there in Paradise.
This one, people doesn't know much. You're not just gonna be like, that's what they got. Right? We done it. We get all trained because we get all the some shit. They won't sit his ass. You even told him shut up.
John said he started these. I said, how long ago? He said it'll go all weekend. John started these. I was like, how long will they go? He said they'll go all weekend.
There's another copy. Donnie, you got a copy as well?
Please.
Call this hearing back to session. The audience is in here, we have no say. Any heckling or anything going on, any voice talking, you're going to be removed. This is all up front. Okay. Introduction of the board council. I have Donnie Bryant, Bill Bruner, Aaron Cook, Chief Hunterfield, Assistant Chief Mike Lanning, Leslie Votal, counsel, Jeremy Diltz, counsel for the chief, Richard Butler, counsel for Mr. Taylor. Court reporter oath.
Yes, basically just to verify on the record, you're the same court reporter as previously, as the previous hearing, and you're licensed and or permitted in Indiana to do such court reporting. Yes.
Is that covered, or do I need to say that?
No,
I'll agree that the court reporter is perfectly satisfactory.
Thank you.
Review pre-hearing with board and parties. Board acceptance of pre-hearing entry, appropriated entry.
Mr. Mayor, I didn't hear that.
It's reviewed pre-hearing with the board and parties. Board acceptance of pre-hearing entry, incorporated with the entry into the record.
I assume you're reading from an agenda. Are we going to talk about these items in the pre-hearing entry, or?
I believe we stopped at number 4, if the parties, from the last hearing, I think both parties agreed at the end of our last session that everything that we had already covered has been duly recorded, and we don't need to rehash any of the earlier objections as they've been noted for the record.
That's my understanding.
Well, that was my understanding too, before we filed our motion in court, and the court determined that the hearing had to be in public. Is it not now necessary that our objections to be of record must be in this public hearing?
Did you get a copy of the transcript, Mr. Butler?
Yes,
The transcript is the record, isn't that correct?
I haven't reviewed it.
Okay. That would be my stance. I mean, that would be up to the board, but the transcript, which, if there is an appeal, is the record that goes to the court. And I did give copies to both parties when I received it, which was just, I think, the beginning of last week.
I
So
didn't receive a copy of the transcript.
you did not receive a copy. How would the parties like to proceed then, Mr. Bell?
What seems redundant, and to go back and go over all of the same matters that we've already agreed to. If the transcript is true and accurate, and I don't have any reason to believe that it's not, I would simply submit that the transcript be made part of this public proceeding, and then it's part of the public proceeding.
Mr. Butler?
As long as we can all stipulate that those objections are of record in this public hearing, and I won't, in subsequent proceedings involving this matter, hear an objection that you didn't make those objections at the public hearing. The court ordered that the hearing be conducted in public, therefore you've waived the argument. My only concern.
I don't have an objection to that.
Then I get, where we left off with the pre-hearing entry that all parties should have a copy of was number 4, the voir dire of the board. After a pre-hearing conference with counsel, we did extend the amount of time to question the board members as to their impartiality or lack of impartiality to 30 minutes. I guess, would either party like to, are we in agreement with that at this time, or?
I'm in agreement with that, but I guess I'd like to follow up with the substance of the email I sent to you and Mr. Butler later on relative to evidence pertaining or alleging to pertain to the biased or unbiased nature of the board itself, in that I think that the case of Adkins versus City of Tell City discusses the rule of necessity, in which case even if some of the board members may be perceived to be biased, that there's no other entity charged with the duty of hearing this hearing, and so I would ask that that be considered before any recusal. I would also request that any evidence or offers of proof made as to the alleged partiality of any board member be made during voir dire as opposed to during the hearing itself, because that is the purpose of voir dire, which is to determine the partiality or potential impartiality of the fact finder. So with that, with those considerations in mind, I agree with that voir dire should be 30 minutes, and I'm happy to conduct it that way.
Mr. Butler?
Just by way of response, I don't think the doctrine of necessity is an issue in this matter, and I'll tell you why. If either one of you members is biased or prejudiced, there's a simple solution to ensuring Doug Taylor's constitutional right to due process, which means a fair hearing by an impartial trier. Resign. The mayor can appoint somebody else who doesn't have that bias or prejudice. There's no necessity. I'm not sure. I haven't looked at the statute. I think Board of Works members may be removable at will at the mayor's pleasure. So you can say there's necessity that biased or prejudiced folks hear Doug Taylor's case, but the fact of the matter is there's a simple solution which abrogates the necessity argument. Resign, or mayor remove them, appoint somebody that doesn't have bias or prejudice. With respect to limiting arguments or evidence of bias or prejudice to the voir dire proceedings rather than to the hearing itself, you can't do it. By doing that, you limit our ability to introduce evidence. We may have other evidence not in the possession of any of you board members that are subject to questioning during voir dire of bias or prejudice. I may have witnesses to testify. I was told this by that board member. And to the extent you've set up this voir dire procedure to foreclose my ability to present evidence of bias or prejudice, I don't think you can do it. Case law is real clear in Indiana that when the court reviews one of these matters, it gets to review whether it was a violation of any constitutional, statutory, or legal principle. With respect to constitutional principles, we've got a right to due process, which means a full and fair hearing conducted in good faith before an impartial body. And what we've got to demonstrate is actual bias or prejudice. And by setting up this voir dire procedure and attempting to limit Officer Taylor's, or Captain Taylor's, forgive me, ability to present evidence of bias or prejudice, you foreclose the entire universe of evidence of bias or prejudice, except from these 4 individuals. Don't think you can do it. We object to it. And to the extent, again, the voir dire procedure is designed to limit our ability to present evidence of bias or prejudice, we object to that procedure as well.
Well, for the board, I don't think that what Mr. Diltz said will keep you from determining the partiality or impartiality of the board. That's exactly what the voir dire process is for. The rest of the hearing, it, however, is not about this board. It's about Mr. Taylor. So the voir dire process is where you get to attack the members of the board like you've already said that you want to do. As far as during the process of this public hearing, the allegations that are in front of the board that were proposed, that were allegedly committed by your client, and actually he admitted to, is the substance of this hearing.
Always an issue in any hearing is due process, fair and impartial, unbiased trier of fact. What Jeremy has said, Mr. Diltz, I'm sorry, you can call me Richard. What Mr. Diltz has said is he doesn't want to hear any evidence of bias or prejudice during the hearing. And that's fine to say the voir dire procedure is about that. Are you going to let me during the voir dire procedure call independent parties who will just flat out tell you that these folks have already told them what they're going to do? They're going to fire Captain Taylor. I understand you don't want that evidence in. If I represented your board, I wouldn't want that evidence in either. And you're going to make a ruling, you board members, and we're going to live by it, but I'm going to get my objection of record. Make your decision, my objection's of record.
If I may.
Yes.
If, on behalf of Officer Taylor, Mr. Butler would like to make offers of proof unrelated to the questioning of the board members as to what he believes the substance of the testimony from these individuals would be, so as to preserve that testimony in any subsequent appeal, whether to a circuit court or beyond, I have no objection to that.
And we are dealing with people on this board that don't normally deal in legal proceedings. Can you explain what an offer of proof is, please?
An offer of proof would be to permit Mr. Butler, on behalf of Officer Taylor, to, in effect, tell you what evidence he thinks he has, what he believes these witnesses would say to you about your alleged bias or prejudice. Since we are being part of a public record, that all goes into the record so that a reviewing court, whether it's the circuit court or the appellate court, then has the ability to look at his objection, what he thinks his evidence is, and from that determine whether any error was made by you in any of the rulings as it relates to your bias and prejudice.
Thank you. How would the board like to proceed?
It doesn't matter if Mr. Butler's fine with that. I'm fine with that. I mean, are you fine with Mr. Diltz's suggestion?
Not at all. Look, it's no secret. Officer Taylor has blown the whistle on the chief, accused the chief of stealing money from this city, committing conversion, committing theft, committing, at the minimum, receiving stolen property. The same with the assistant chief. He's alleged, Mayor, that you've committed crimes, you, Donnie, you, Mr. Bruner, and you, Mr. Taylor. I think that creates bias and prejudice. We intend to introduce evidence that demonstrates that there's a factual basis that ought to be of great concern to you all that he's blown the whistle on for those allegations. All that, I think, is evidence of bias and prejudice. I don't have any interest in attacking anyone, as Ms. Votal has said, but what I do have an interest in is doing my job. It's an unpleasant job for me. I know each and every one of you. Think well of each and every one of you. I think you're human like me, human like Doug Taylor, and you've made mistakes. I just don't want to see Doug Taylor lose a 22-year career, nearly an unblemished career, because he made a mistake too. And I think because he's made those allegations, reported them to the prosecutor, reported them to the chief of police, reported them to the others, it puts you all in jeopardy and peril. And I think to a reasonable mind, creates some animus or some bias or some prejudice. We've got a lot of evidence of that. Not just a witness that says he told me, but we've got payroll records. We've got contracts. We've got minutes. All those things go to confirm and corroborate what Doug Taylor has said in his complaint to the chief and to the prosecutor about the criminal activity. So to the extent I'm limited from bringing that up, I think we've violated his constitutional right to due process. Again, if we don't like the decision you all make, we get a file in the court over there. And the court gets to look at whether there was any bias or prejudice. If I'm not permitted to make a record of bias or prejudice, how does the court get a look at that? And tell me, in this public hearing, what's the difference between Richard Butler putting the witness on or the records in and Richard Butler saying instead, the offer of proof, this is what the witness would say, this is what the records are. I don't see the difference.
I think there are two issues that I want to discuss out of that, and I'll take the last one first. I think the first issue is that if the board determines that an offer of proof is sufficient, we're going to greatly decrease the amount of time that we're all spending here. So as a matter of administrative and judicial efficiency, I think that that's important. Secondly, an offer of proof does exactly what Mr. Butler says he wants, which is preserve the objections, preserve the facts that he thinks that the testimony or exhibits would elicit. But there's a related concept in what I've just heard, and that is this notion that you've all been accused of crimes and that Mr. Taylor or Mr. Butler, on behalf of Officer Taylor, is going to, in effect, try to prove that and show your bias. And I think that there's a separate forum for that, and if that's if you get prosecuted. The job of the criminal justice system is to prove whether or not you have committed a crime. It's the process that Officer Taylor went through. That's the goal of the judicial system. That's the function of the criminal justice system. It's not an appropriate area of inquiry in a situation like this, where the only function of this hearing is intended to determine whether or not Officer Taylor
you take it outside
by the police department. So it's those issues aren't germane to why we're here. It's not why we're here. And second, if there is an issue with any alleged criminality and proof of criminality, there is a forum for that. And that's where the prosecutor or law enforcement agencies, the FBI, etc., that's where they would come in. They're not here. And so I think it would be inappropriate for Officer Taylor to try to prove those things today in this forum when there's a separate forum for that, if there is ever any such evidence.
With all due respect to Mr. Dilts, it's easy to stand there as he does, as attorney for the fox that guards the hen house, and say, report it to the authorities. We reported it to the authorities. The chief, we accused the chief of crime. Chief didn't even recognize he had a conflict of interest in deciding what to do with the allegation that he's committed a crime. Didn't send it on to the state police and say, I've been accused of a crime, investigate me. And he sure as heck didn't say, let's investigate the mayor that appointed me to this job and gave me nearly a 50% raise. And he sure as heck didn't say, let's investigate each of the Board of Works members who controls my department. Convenient to say, there's a forum for that. Unfortunately, the way the world works in Lawrenceburg, it's a deaf forum. I understand what you all want the hearing to be about. We think there's bias and prejudice. We're put in a position of having to make, we don't want to be here making that bias and prejudice case. Don't want to be talking about any of these things I'm talking about. But I represent Doug Taylor. It's my job to make sure, under the constitutional principle of due process, as it gets in a fair and impartial trial. And so I've got to explore these issues of bias and prejudice.
You've heard both arguments at length. The offer to prove seems like the most reasonable for the reasons Mr. Diltz put forward, the timeliness of this hearing. We've already been in 25 minutes and haven't moved past the first issue. I don't believe it's an appropriate forum, as I would instruct my board members, if any of these allegations, criminal allegations, are brought or asked of the board members, that they plead the fifth. There's no reason, this is a public hearing, it's being recorded, they could incriminate themselves. They have the right against self-incrimination. Not that, any of it's true, but they do have the right to plead the fifth. And that has been my instruction to them if they're asked questions about the March 14th letter to Aaron Negengard.
Well, I'd like to say one thing in response to Mr. Butler's comment. He said that's the way that things work in Lawrenceburg, but that those accusations were also sent to the state police and the FBI with the same results as the Lawrenceburg. So it just isn't Lawrenceburg. I mean, they looked at the same evidence.
The letter was forwarded to
The state
all
police.
entities,
And FBI.
so the
You said that's what-
FBI received a copy as well.
The
So
point being,
You said that's the way things work in Lawrenceburg, but you forwarded to those entities as well, so it just isn't handled by Lawrenceburg.
well, yeah, it does. Nobody investigates crimes, and the guy responsible is sitting right across there. He runs the department that is responsible for investigating crimes in the city of Lawrenceburg.
Well,
Not the FBI, not the IRS, not the Indiana State Police.
But as
They
you,
don't-
as you said, the Indiana State Police has to investigate if he's charged with a wrongdoing, correct?
I did not say that.
I
I
believe
said-
that's what you said.
What I said was the chief failed to recognize he had a conflict when he receives a complaint from a citizen that he's committed a crime. He ought not pass judgment on whether there's anything done about that. He ought to pass it on.
And that's what was done, Mr. Butler.
The
was-
chief passed that on?
I know that it was passed on to Mr. Negengard, that's who it was addressed to. I believe the Indiana State Police, Mr. Negengard is here to testify today, that's something you can question him on.
I don't understand what you're saying.
I believe those things did happen. At this point, the board needs to make the decision on whether the offer of proofs on this, on what he wants to present is the right way to go. I believe it is, because it does preserve the objections for any appeal that Mr. Taylor would have. This is not the appropriate forum in the timeliness of this hearing. So I guess the board needs to make a decision. Each one of you can let us know.
I'm here to listen to the facts of the case, and anything outside of that, such as a letter, which I have not read. I don't believe Mr. Taylor wrote the letter to that fact. I haven't read it, so to me, this is hearsay. And I'm not here to discuss that. I'm here to discuss the facts of why we're here. Other than that, there's nothing else to really talk about.
Well,
I mean, isn't that the purpose of this meeting? I think the facts will tell the case, and I don't know all the facts. I believe that's why we're here. So,
Mr. Bruner, I think you and the rest of the board members are going to be surprised that you aren't going to hear much debate about the facts from us. We think everybody's known since day one what Officer Taylor did. He certainly admitted it since day one. this deferred prosecution agreement any great revelation where he admits to these things. He admitted to them the day after it happened. And it wasn't any secret anyway. Everybody was there. I don't know if you were there or not, but a lot of people were there. Everybody knew it was there. No secret. So you won't hear a lot of dispute about the facts. But again, I appreciate that's why we're here, and I appreciate what you're saying, and I sort of agree with you, except don't miss this point, please, Mr. Bruner. Doug's entitled in this hearing, where you got to hear the facts, to a fair and impartial hearing, where you all don't have any bias or prejudice. Now, I don't know how we decide that other than hearing evidence about it. I don't know how when I go, if I don't like the decision here, when I say I mean Captain Taylor, I don't know how I go to the court to appeal that decision and show the court, here's my evidence of bias and prejudice, if you're going to refuse to hear it. Now, certainly what Mr. Dilch says, the offer of proof, what your counsel says is a way to do that, but just please do understand, I understand we're here for that issue. You won't hear a lot of debate about that, but we're also here to make, and me in particular, make sure Doug Taylor gets a fair hearing by an impartial, unbiased group of folks.
Thank you. I guess
Aaron?
just keep it going.
My opinion, I don't mind hearing Mr. Butler's accusations, because, I mean, I've committed no crimes, and, I mean, if it takes 6 hours for his accusations, it doesn't bother me. I've got my whole night mapped out for me. It's no
Let me
problem
say
with
this
me.
too. Leslie, to your point about pleading the fifth, I don't intend to ask any of these gentlemen whether they committed an act that constitutes part of a crime or whether they committed a crime. Don't intend to do any of that. So that's not going to be a problem. Look, I'm not here to crucify these guys. Again, I don't want to be here. I don't want to have to be talking about whether you're all biased or prejudiced, but there's evidence of that. And it's my job. Please respect it. I'll respect the job you all got to do to talk about those issues and ask you to make the right decision on those issues.
And at this point, I think the board, we can do that on a case-by-case basis as the voir dire is happening. That sounds like the best way to do it. If I find that there's an objection to be made, I will object on the voir dire because I'm your counsel. And if at any time you need to speak with me, that's fine too. The next thing, number 5, is hearing in a public session.
What's the,
We'll address that as we go, as he's asking the questions. I mean, that seems like the only way we're going to be able to do that. If there's an offer of proof that needs to be made, and Mr. Dilch, wants that to happen.
what about Donnie?
Let's get Donnie's view. Donnie?
Oh, I think I can, let the brother be fair and partial. I've been friends with Doug ever since I've known him. The letter, I have not read it or seen it. I've heard say of it. I've heard say of the prosecutor saying it was being banned, addictive he was. But I think I can make a fair and partial.
So, at this time, as far as the voir dire of the board, we have in here that to permit the parties to explore the factual basis for a request for recusal or motion to disqualify a member at the beginning of the hearing. Each party will be allowed 30 minutes to question board members as to their impartiality or lack of impartiality. The board needs to decide if you're going to give Mr. Butler more leeway with that 30 minutes.
Aaron?
It doesn't matter to me. It doesn't matter to me whether it takes 30 minutes, 30 hours. I mean, I want him to get, all his accusations out. Why the board's impartial.
Bill?
I don't want to sit here for 30 hours.
I don't either, but
Again, and I'll say it again and again, we're not on trial here. Bottom line, we're not on trial. We're here to listen to the facts of the case, and that's it. I'm not going to sit here for 10 hours and be put on trial. It's not going to happen.
Donnie?
I'm the same way. If there's something that you're dead sure somebody's done wrong, I think you should go through the process like Taylor did, go to the court. I don't want to sit here all night either.
So the board's okay with limiting it to 30 minutes to question the board members? Second.
Aaron?
no.
Bill?
No.
Yes.
Donnie?
No. Not 30
as we said, well, then we will have to do it on a question-by-question basis. Board counsel previously advised the parties of the hearing be held in an executive session, but obviously, we've since notified the parties of the hearing being a public hearing, and that notice was posted on August 23rd, 2013. Then the required 48 hours notice. Separation of witnesses will be granted when either party requests and the non-requesting party does not identify that the separation would be fundamentally unfair. So if either party would like to request that this time, that would be time to do it.
I'd like a separation of witnesses.
This is up to the board, reviewed by the board on such a request. Basically, what that means is that no other witness can be in the room if they are subpoenaed to testify. So they would have to leave the room if they're subpoenaed to testify by either party. And the whole point behind it is that you don't want other people to hear another witness another witness is testifying to.
Aaron?
Yes, on board.
Separation. Don?
Separation.
Okay. At this time, I would instruct anyone that was subpoenaed to testify today in this hearing, leave the public chambers. I think number 7 is opening statements and closing argument, and I believe we did go through the rest of these besides the voir dire. Are there any objection by either party to the rest of these procedures?
I don't have any specific objection, but as a follow-up to the email I sent today to both you and Mr. Butler, I think, and I don't know if it was incorporated subsequently, but I don't believe that this order provides for redirect of your own witnesses, and I would ask that be accommodated.
Do you have any problem with that, Mr. Butler? As far as redirect?
Probably not. Where would that fit in, Mr. Dills?
I think it was under order of proceedings.
Okay, let me just read that real quick. In general, I have no problem with redirecting your own witnesses.
And I think his reasoning, Mr. Butler, is that cross-examination is not limited to the subject matter of direct examination because of the nature of this hearing.
And that it was anticipated that each side will only make one pass at each witness. My thought is, if I call someone, or if you call someone, and then there's cross-examination on material that we didn't discuss in direct exam, then whoever called the witness initially is foreclosed from discussing any of those new issues.
I've got no objection to redirect, but I've got no objection to passing the witnesses as long as you want to pass them. I don't think it'll take them a couple passes.
Well, I mean, I think that can be a decision by the board as far as that goes. Okay. Now, as we stated also in the pre-hearing conference, after the conclusion of the hearing, we are asking that the proposed findings of fact from each party be submitted to my office by 12 p.m. on Monday, September 9th. They're also exchanged copy with the other party. And if you could please do that by email and Microsoft Word format, that would be great. Be greatly appreciated. And then the board will consider the proposed findings of fact and conclusions of law submitted, and we can use our own, either parties, or develop our own findings. And then I think I did talk with you all about meeting then on, and I think this should say the 11th day of September at 5 o'clock, which is a Wednesday. I think that's a typo. The 10th was, I think we talked about the 11th and the availability of both parties for the 11th at 5 o'clock to have the public meeting on the vote on whether to terminate the officer's employment.
I have it as the 11th.
Was that okay?
No objection.
Okay. Other than that, then, we would then proceed to ask the board to incorporate this entry, accept the pre-hearing entry, and incorporate the entry into record.
Motion board,
I'm so moved.
second? Second. All in favor? Aye. Have a roll call, please.
Aaron Cook,
Yes.
William Bruner,
Yes.
Tony Bryant,
Yes.
Ayes have it.
And I will make sure the court reporter gets a copy of that entry. We will proceed with the voir dire of the board.
Did you want that to start with me, Linda?
Yes, that would be fine, thank you.
I just want to ask any of the members, all of the members of the board, whether you've ever been indicted for any crime, you've been indicted for any crime in the last year.
No.
To your knowledge, have any of you been investigated for any crime related to your employment with the city or with your participation on the Board of Works or other position with the city?
No.
I think through lots of hearsay, yes. It sounds like we've been investigated by everyone under the sun. So,
I'm sorry, maybe I should be more specific. Investigated by a law enforcement agency
no.
How does that know?
or by any other prosecuting entity, such as a federal or state prosecutor?
No.
I have nothing else. Thank you.
Thank you. Mr. Bowe?
Thank you. Mr. Mayor, do you agree with me this evening, wouldn't you, that we're here tonight, or you're all here tonight, to fire Captain Taylor?
We're here for a hearing.
Is that correct?
We're here for a hearing.
And what are we doing at that hearing, Mr. Mayor?
Listen to the facts.
Are you aware that you've been accused by Officer Taylor of committing multiple crimes, many misdemeanors, many felonies?
I've read the paper.
You're aware of that?
I've read the paper.
What paper is that?
Local paper.
Are you aware, I'm concerned with whether you read the local paper, but are you aware that Officer Taylor has accused you of committing many crimes, including this felony?
Like I said, I read the paper.
Okay, I read the paper too. What I want to know is, do you know whether Officer Taylor has accused you of any crimes, including many felonies?
Personally, he hasn't said anything to me about it, no.
But do you know that he's done that?
The only thing I just read the paper, like I said, I don't know if he hasn't.
Okay. Nobody's talked to you about a letter? Your chief never told you he got a letter saying, I need to investigate the mayor for committing crimes? Nobody else ever told you that there was a letter out there where Officer Taylor accuses you of committing crimes?
I don't know.
What'd you read in the paper that makes you say that in response to my question about whether you're aware Officer Taylor has accused you of many crimes, including many felonies?
The only thing I said was the paper, I read the paper. I don't know if he has personally accused me, no.
Did the paper say he accused you?
Accusations.
So the paper said he made accusations that you committed crimes. Is that correct? Including many felonies.
That's what's in it, yes.
How's that make you feel?
Doesn't make me feel very good, 'cause I didn't do it.
Wouldn't make me feel good either, to be honest with you. Mr. Bryant, same question. Are you aware that Officer Taylor's accused you of committing many crimes?
Not personally, just hearsay. I don't buy the paper, I don't read the paper much.
Okay. What do you know about that?
I just, like I say, hearsay. I mostly heard it was dismissed. The prosecutor said he was just being vindictive. I think it's the right word.
I believe that is what the prosecutor told the press. But again, and I just want to be real clear. Are you aware that Officer Taylor has accused you of many crimes, including many felonies?
I don't know if there's felony or anything, but I know he made some charges against me. I don't know if there was felony charges or what. I couldn't tell you.
Fair enough. Mr. Bruner, are you aware that Officer Taylor has accused you of many crimes, including many felonies?
Yeah, personally, I don't think Doug wrote the letter. Obviously, everyone says he signed it, but I've known Doug for a long time and just can't see him doing that. But I've never read the so-called allegations, the paper, whatever, but just through people talking through town.
You're aware they're out there?
Yes.
Mr. Cook, are you aware of the same thing?
Yes.
Now, what, Mr. Mayor, after you hear the evidence, do you have to decide in this case?
I don't get to vote. Only I vote's within a tie, but three of them, there won't be a tie.
Okay. Well, what if one abstains? And one votes yea and one votes
Will be
nay?
a tie.
Okay. And do you know at that time what you're called upon to decide?
What the evidence proves.
Okay.
How, am I allowed to, I don't know the proceedings, am I allowed to speak and respond to anything else at this time or not?
I think,
It has to do with what he just asked me, but, because he asked some people, how does that make you feel, and he didn't ask me that, so I was just wondering why.
I'll talk to you after the hearing. Don't be offended if I don't ask some of you the same question, please.
My only point to that was, I was waiting for you to ask me how it made me feel, and it doesn't make me feel one way or the other as far as I go. My other city council members write slanderous stuff about me in the paper on a bi-weekly basis, and I vote with them every other week. So, I mean, it doesn't affect me one way or the other.
Is it true that you've all met in executive session before you got to this point to discuss Captain Taylor? Okay. On multiple occasions?
I guess as an objection, or I guess more a point of clarification, I'd like to know if you're including the last time that we were here for this purpose.
Multiple executive sessions? No, leading up to these hearings.
Okay, so excluding the former session.
That's fine.
Okay.
One time.
Mr. Mayor, it's your testimony. You've had one executive session about terminating Captain Taylor's employment.
You don't know, then you say you don't know. I can show you exactly what it was, but he's
At this
asking
time, I don't
questions.
remember what happened. A lot of it.
Okay.
We discussed what the allegations was.
You don't know how many executive sessions you had?
Yeah.
Do you know whether you had executive sessions advertised for the purpose of discussing strategy with respect to this hearing? Is that yes?
We had two.
And with all due respect, I appreciate if the answer, or if the witnesses can answer the questions without first conferring with you.
Okay. That's fine.
And if you instruct them as well.
I don't remember how many we had.
But I appreciate you don't remember how many. More specifically, did you have any executive sessions for the purpose of discussing strategy with respect to this hearing? Because I can tell you I saw at least a couple of notices that say you did.
Yes, we did.
At least a couple times, maybe? Sound right?
Maybe a couple.
Don't let me put words in your mouth. Mr. Bryan, is that your recollection?
We had a couple to advise us, because like she said, we're not familiar with the laws and the procedures, everything.
Okay.
And we was notified of his rights and what we could expect,
Okay.
you know.
The notice said you were getting together to discuss strategy with respect to this hearing.
It wasn't
Is that what you-
strategy, I don't think more, it was the proper procedures that
Okay.
would have to be taken.
Would you agree with that, Mr. Mayor?
Yes.
Mr. Bruner?
Yeah, I remember meeting with Mr. Diltz and actually being informed on, what was going to happen, the process, that kind of thing.
Okay. You remember coming to one or two meetings, executive sessions advertised for the purpose of discussing strategy with respect to this hearing?
No.
Okay. If that's what the notice that was sent to the media says, you wouldn't disagree with that, would you?
Well, I think we had a meeting, maybe possibly a meeting called, and then I believe we didn't end up having it.
The notice said strategy? I have that.
Okay. Mr. Cook, do you recall whether you went to any executive sessions noticed for the purpose of discussing strategy with respect to this hearing?
As we talked about in the first executive session, I didn't look up the IC codes, and we discussed and agreed upon that they might have been advertised wrong.
Did you see any of the notices that were put out for the executive sessions you attended about Officer Taylor?
Only the executive sessions at that point had the just the IC code. They've changed them now, and you said that's a lot better. But at that time, they were just the IC codes, and I didn't look up the IC codes.
I understand that. Do you remember any of them saying they're for purposes of discussing strategy with respect to litigation?
No.
How come this board never took any action, and I'll ask you, Mr. Mayor, to terminate Officer Taylor's employment until after he blew the whistle and accused you all, and your chief and your assistant chief and several other city officials of committing multiple crimes?
Don't know.
Mr. Bryant, do you know why?
Say the question again.
I want to know why this board never took any action to terminate Officer Taylor's employment until sometime after Officer Taylor blew the whistle and accused each of you all, and your chief and assistant chief and other city officials, of committing multiple crimes.
I don't think it was because of his actions of accusing us. I think we was waiting on the prosecutor's decision, and then, like I say, we had a couple work sessions to figure out the right way to go.
So if I'm fairly understanding you, you don't think you decided to take action because Officer Taylor accused you all of crimes, correct?
No.
Okay. But do you know why you didn't do anything until after that?
I think it was mostly waiting on what the courts were going to decide, and then he was entitled to a hearing.
Okay. Mr. Bruner, same question. If you remember it, if I need to repeat it, I'll try.
We were actually waiting on the disposition of the case
For what?
to find out what the outcome was.
What was the outcome, as you understand it?
He had made a deal, pled down to a conversion, I believe is what it was. So, and I
So
believe,
do you believe Officer Taylor has pled guilty to something?
the case is over and there was a disposition.
Okay. And so you do believe Officer Taylor has pled guilty to something and been convicted of a crime?
He's admitted to whatever he did to
Okay.
get a conversion, I believe.
I need to stop you right here, Mr. Butler, because I do think that the court's decision is instructive to the board at this point as far as the disposition in this matter. The court did decide, the circuit court did
Just don't
decide.
count against my 30 minutes.
I know, I won't. But the court did decide, we did get an order on the complaint. There was an injunction filed by Mr. Taylor late last week. We had a hearing on it on Monday morning. The two issues were the executive session issue, which we conceded and obviously having a public session. The other issue was whether or not his deferred prosecution agreement, which we will be presented in exhibits, was a disposition of the criminal charges. The court did find, and I'll read it, that considering the contents of the deferred prosecution agreement in light of IC Code 36834, which is the statute we are proceeding under, this court finds that the Board of Public and Safety is not required to stay proceedings until such time as the case is dismissed and/or subsequently prosecuted by the prosecuting attorney. The court finds that disposition of this case in the trial court for purposes of Indiana Code 36834N has been the entry of a deferred prosecution agreement. In making this finding, the court notes that on the face, the deferral agreement that Mr. Taylor has admitted to the allegations of the criminal charges. In addition, the notice to Mr. Taylor of March 27, 2013 alleges possible grounds for discipline or discharge which are independent of criminal charges or their disposition. These allegations include what was in our March 27th notice, any act of malfeasance, 2, conduct unbecoming an officer while on or off duty, 3, violation of any existing laws, 4, neglect of duty, 5, violation of any rule or regulation, and 6, using authority for personal ends. At that point, the judge did deny the request for the stay of the proceedings. and granted by agreement that such hearing be held in public, so just wanted to let the board know. I'm sorry, I should have brought that up at the beginning.
No problem. Mr. Burns, same question. Do you know why this board didn't take any action until after Doug Taylor accused all of you, including the chief, the assistant chief, and other elected officials, of committing multiple crimes?
Once again, we were waiting on the disposition of the case.
At what meeting did this board take official action and decide it was waiting on disposition of Officer Taylor's criminal case?
I can't tell you offhand what meeting it was.
But did it happen at a meeting? Because board works can't take any official action without a meeting.
I'm pretty sure I was there.
Okay. But you don't know when it happened.
We have a lot of meetings, Mr. Butler.
Should be in the minutes, though, if it happened.
Absolutely.
Okay. So is it your contention, then, that your proceeding to terminate Officer Taylor now has nothing to do with his accusing you of criminal charges?
Can I ask a question?
No. It's my turn to ask questions. Don't mean any disrespect. But that's the way the procedures you all agreed to adopt work.
Okay, could you ask the question again then?
Could you please repeat the question?
But you don't, we'll talk about the meeting, but you don't know when it happened, it's waiting for the meetings portion, but it should be in the minutes when it happened, that's right, absolutely. So is it your intention then that you're proceeding to terminate Officer Taylor has nothing to do with his accusing you of criminal charges?
Has nothing to do with his allegations.
It was just because you were waiting to see what happened with his criminal case.
Yes.
Mr. Cook, do you know why this board never took any action to terminate Officer Taylor until after Officer Taylor accused each of you, the chief, the assistant chief, and other elected officials of committing multiple crimes?
Yes, because he released that letter the day before or the day of his plea agreement. So it happened at the same time.
Okay. And what's the significance of the plea agreement?
This court was like the case was,
And let me correct that, deferred prosecution agreement.
that it was completed. I mean, that
Okay. Your March 27 letter, your notice that you're required statutorily to give to Officer Taylor, says the charges against you, what you're here to decide today, stem from your admission and confession to the probable cause affidavit and information in your criminal case set out in the deferred prosecution agreement filed with the Different Circuit Court on March 18, 2013. So I guess, is it fair to say you all took action because he admitted and confessed to the probable cause affidavit and information in his criminal case?
you're talking to me.
Sure.
Yeah, as long as it's, I mean, that's what I guess they were. I mean, I don't remember any meeting about waiting until after the court case. But I'm assuming everybody was just waiting until in their heads waiting for it. But I don't remember that actual meeting. But yeah,
Let me ask you this, Mr. Cook. To you, what's the significance of the deferred prosecution agreement? Why does that trigger you, as a Board of Works member, to want to now consider terminating Captain Taylor?
because I mean the court that case is completed as long as I guess he's on some kind of probation. But everybody's innocent until proven guilty. So you don't want to terminate somebody that's innocent until after the court case.
Thank you for that. It sounds like from talking to you and Mr. Bruner that maybe this board doesn't really know what that deferred prosecution agreement says. Is that fair?
I've seen it, but you can refresh my memory if you'd like.
Well, and Leslie, interrupt me if you think I'm wrong. I mean, the agreement speaks for itself. In general, I think your counsel and I can agree that Officer Taylor didn't plead guilty to any crime.
He admitted to the crimes he was charged with.
Officer Taylor absolutely admitted to the conduct that constitutes the crime. He admitted that he committed the crime.
So you just said he
That's
didn't admit
different than a guilty plea.
Yeah, you said he didn't admit to any crimes.
No, say he didn't plead guilty.
Okay.
I think that's what I said.
Okay, I didn't know we were playing on words here.
Here's
But
my
okay.
point. When you plead guilty, there's a judgment of conviction. The court convicts you of a crime. You are convicted of a crime. I think your counsel and I will agree. Officer Taylor was never, ever convicted of a crime in this matter. What he did say is, I did it. But by the way, guys, he's always said that, and our evidence will show it. So if he's always said that for 2 years before he entered into the deferred prosecution agreement, my question to you is, why now that he says the same thing he said for 2 years, but now he says in the deferred prosecution agreement, do you as a Board of Works member now want to consider terminating his employment?
Me again? I would never try to terminate anybody until the court, and went through the court system, was complete through the court system. I mean, no matter what the charges or anything. I can only speak for myself, though.
Mr. Bruner, assume that Officer Taylor has always admitted that he did what he admitted to in the deferred prosecution agreement. Why then wait for the deferred prosecution agreement before you consider terminating?
Well, it has been my experience that in any court, you're innocent until proven guilty. So I think there's a lot of liability when you just say, hey, so-and-so got in trouble, but we're going to go ahead and fire you. We don't know what exactly happened.
Fair enough. You understand, Officer Taylor's never been proven guilty.
I read what, if he was never proven guilty, I understand that conversion or diversion, whatever you want to call it, but if he's on probation, to me that says he did something.
Okay. And let me tell you this too. I think your counsel and I agree. He's not on probation. Probation is something you get when you're convicted of a crime.
And I can expand on that.
The judge will sentence you to probation.
I can expand on that. The diversionary agreement in Indiana has to do with if he commits another crime or violates any traffic laws. The normal diversion states if you during a period of a year until next April 1st, he is on a type of probationary period. It's not probation as in the real sense that we as lawyers know as probation, but if he messes up during that time and commits any other crimes or is charged with any other crimes, then the prosecution can recommence against him on the D felonies. And the effect of his admission in that agreement is he did admit and confess to all of the information and the probable cause in that, supporting the facts that support the criminal charges. He also stipulated, basically waived his right to object to that admission in that agreement if it were to be prosecuted. So that was the basis that the circuit court, I think, found that this was a disposition of the criminal case.
And I'm not concerned with the circuit, but I am concerned that you all understand what happened. He didn't plead guilty. He wasn't convicted. He's not on probation. He entered into an agreement with the prosecutor. And he said, I'll resign my position as a councilman with the city of Lawrenceburg. And I admit that I campaigned in uniform, a Class A misdemeanor, and that I committed conversion, a Class A misdemeanor, I think, maybe a C, because I got paid for that 2 hours and 11 minutes I was up there at the campaign event. And Mr. Prosecutor, in exchange for me doing that, you won't prosecute me. As long as I don't get into trouble again, commit another crime on April 1, 2014, you'll dismiss the case against me. Not only will they not have been convicted, the charges are dismissed. But certainly, there's an admission that he did these things. But we intend to show you and assume, for purposes of my questioning here, that he always admitted that. There wasn't ever a secret about it. This wasn't a whodunit, folks. It was damage control. We all know he did it. Everybody knows he was up there. We don't deny he was up there. So my question is, if he admitted that on the front end to your chief the day after, a week later to the assistant chief as well, and there's a record of it, why do you need to wait? You've got everything you need to know at that point. He admitted to doing it, but you didn't move for 2 years to terminate him. You only moved to terminate him once he accused you of each of the crime. And I guess I'm saying, why? You knew everything.
Well, I think you was representing him during that period, and didn't you keep getting extensions and everything?
On the criminal hearing? Well, I got delayed for several reasons, but that's irrelevant. The point is, and my question to you is, your police department that you're responsible for, your chief that you appoint, knew the day after Doug Taylor was at that campaign event that he was there and Doug admitted it. He knew Doug Taylor got paid for being there. I don't know how the procedure works. He might have signed a voucher and getting paid. He certainly didn't do anything to stop Doug Taylor for getting paid for those 2 hours and 11 minutes that he knew he was up there. And a week after, the chief and the assistant chief sat Officer Taylor down and said, hey, how do you plead? He says, I did it. I made a mistake. I messed up. I'm sorry. Please forgive me. And they reprimanded him. And they put a record of it in his file. And that was the end of it. Fast forward 2 years, he accuses you all of a crime. Now the discipline that was administered, the reprimand, isn't adequate. Now we got to terminate him. We got to terminate him because now we got this thing where he admits. We already admitted 2 years ago your chief knew it. You're responsible for that department. So my question to you is, why now do you want to terminate him?
I believe that's been asked and answered, Mr. Butler.
I
I
can-
think all three of them have given adequate answers at this point.
It's the same way to our union reps, if somebody's got a grievance, if they've done something wrong, we work for the public expects us to keep the house in order, and sometimes a union grievance will take a year or even more to go through, and we don't make a decision until all the facts are in. It's a wait and see, and we're not always going to say everything, we try to get all the facts and everything.
And Mr. Bell, I can only speak for myself again, but that's been my procedure, my policy since I've been on here. As far as there was another city employee that allegedly committed a crime, and I made a motion to suspend until after the court case. I believe that's the fair way to do it.
Mr. Bruner, you made reference to you being investigated by everybody. You're aware that U.S. Attorney Joe Hogsett has a special government corruption task force that has subpoenaed some records from the city.
I don't know his name, but I'm aware that there's been records subpoenaed from us.
By a U.S. attorney.
Not necessarily a U.S. attorney, but
Okay.
they've been subpoenaed.
I guess my question to you is, do you know whether, you know what, forget that question. Can I have just one moment? One other question. Or a couple. Let's do a tag when lawyers say one other question, that means several. Mayor, have you ever told anybody that you're going to fire Doug Taylor?
I recall.
Do you recall telling Paul Seymour on more than one occasion you're going to fire Doug Taylor?
I don't remember.
Do you remember telling Mr. Booth outside the Walmart store in Aurora when he asked if you're going to take care of Captain Taylor, that you're going to show that boy no mercy?
Who's Mr. Booth?
Do you recall that?
Who's Mr. Booth? I don't know.
Mr. Booth is Mr. Booth. I don't know how to explain it anymore. You either recall telling Mr. Booth that or not. I assume that you don't know a Mr. Booth.
I know
You
Mr.
know-
Booth.
Do you know a David Booth?
Yes, I do.
You know his father?
Yes, I do.
Okay, I'm talking about his father.
I don't remember.
Okay. You understand why reported to Captain Taylor that he said those things, he'd be concerned that you may be biased or prejudiced and may not judge him impartially and fairly. Let me ask you, Mr. Bryant, have you made any statements to anyone to that effect, that you're going to fire Doug Taylor?
I do not believe so. This is a small town. That's the buzz going around, what's going on with Taylor. And my answer to him was, he's due a trial. He's entitled to a hearing, and the decision will be made after a hearing.
Mr. Bruner, did you ever tell anyone that you're going to see to it or you're going to fire Doug Taylor or vote to fire Doug Taylor?
No, I was told to not talk about the trial itself, the hearing, whatever you want to call it.
You've never made any statements like that?
No.
Mr. Cook, have you ever made any statements that you're going to vote to fire Doug Taylor or fire Doug Taylor? Pardon?
No.
Thank you, sir. Have nothing further.
Before we go any further, based on the questioning, I thought I provided the chief's exhibits C1 and C2 to the board at the last hearing, but it sounds like, which included the probable cause affidavits and the deferred prosecution agreement, but it sounds like some of the board members don't have them. At this time, if you don't have them, I'd like to distribute Exhibits C1 and C2. C2 is the SOPs in effect after 2005.
I wasn't present at the last meeting.
I don't think I have it either.
I wasn't sure if they would had brought their copies over, Chairman.
So I got
Is this just at this more dire stage for informational purposes? This is not yet evidence in the case?
No, it's my intent to rely on these as evidence in the case, just as I instructed at the last hearing.
Okay, but you're not admitting them into evidence at this point?
I think they're admitted into evidence as soon as I hand them to the board, which is what I did at
Okay,
the
well,
last
I have an
time.
opportunity to see them, an opportunity to object.
I provided them to you at the last board hearing, but I have an extra
You may
copy
have-
for you.
If you did, I didn't mark them, and I can't discern them from the 100 other pages of my file. That's fine. Thank you, Mr.
I have so many copies of those, Jeremy. I don't know. Let's see here.
Thank you.
We just want to make sure there's
You still
a
have
original.
one.
Here we go. I got it.
Ms. Votal, I've got no objection to C1.
Which is,
I have no objection to C2 to the extent it just shows what Doug Taylor signed for as the SOPs. To the extent Mr. Dilts alleges these are the SOPs in effect since 2005, I do object. I think that remains to be seen. For these to be the SOPs in effect since 2005, there's a statutory procedure, and we've asked witnesses to appear, we've subpoenaed witnesses, asked them to bring along evidence so we can determine whether indeed these are properly adopted by the Board of Works as a standard operating procedures or the rules of the police department in accordance with the Indiana Code.
I do think the proper party from which those documents should be procured would be the chief, and you have subpoenaed those records, is that correct?
Well, I've subpoenaed the SOPs from the chief. I've subpoenaed from the clerk treasurer, the keeper of the records, copies of minutes showing all rules, regulations, policies, and whatnot that have been adopted by this Board of Works that govern the police department. I haven't called her as a witness yet. She hasn't produced all the records yet, including those records, so I don't know. I just don't want to concede that these were properly adopted and therefore applicable at this point.
And to be clear, these aren't the entire SOPs, they're simply the rules and regulations. I don't want to bring the whole stack because I don't intend to rely on them. So I don't want anybody to think I'm hiding anything. This is not the entire set of the SOP.
We all agree on that.
All right.
And indeed, these were the copies that were sent to you to begin with the March 27th.
March 27th, no question. But again, we're questioning whether the proper statutory procedure was followed to adopt those. To the extent he's saying it is, we want to put him to his proof.
We note your objection. At this time, we move to admit C1 and C2.
Mr. Dilts, I did have these in my file when I was preparing today. I wondered why they were in there.
Now you know.
Thank you for the additional copy.
I'm sorry, you so moved?
Yes.
The board would like to admit these into evidence as C1 and C2. Mr. Bryan?
moved.
Second.
All in favor?
Aye.
Ayes have it.
Mr. Dilts, your opening statement.
Would you prefer that I go to the podium, or is here fine? Does it matter?
I don't believe you're using the recordings. We're not using the recording equipment, so does it matter? Are you able to hear him? That would be fine.
Okay. Well, I think we've heard most of this already, but I am a lawyer, so I will be redundant. Officer Doug Taylor, as a candidate for City Council, falsely reported working for the Lawrenceburg Police Department when in fact he was campaigning while in uniform. He accepted payment from the police department even though he was campaigning and not working. That's not legal. Officer Taylor was prosecuted and entered into a deferred prosecution agreement in which he admitted committing 2 Class A misdemeanors, conversion and campaigning in a police uniform. Officer Taylor's dishonest criminal activity is why we're here today. Not because of you, because of Officer Taylor. His dishonest criminal activity has practical consequences in the operations of the police department. It has practical consequences on his ability to function as a police officer, and also reflects poorly on the department, as one might expect. After all, the very function of the police department is to uphold the law, and an officer who breaks the law he is supposed to uphold is not the kind of representative that the Lawrenceburg Police Department wants among its ranks. For that reason, and for that reason alone, the Lawrenceburg Police Department is seeking the dismissal of Officer Taylor from the department.
Thank you. Mr. Butler?
Bear with me 1 moment. Captain Taylor, we don't dispute, made a mistake, an honest mistake. And an honest mistake is a crime. Don't dispute any of that. He did go to the meeting at 3 Mile Ridge. By the way, the 3 Mile Ridge is in Lawrenceburg, the area where he is a police captain. 3 Mile Ridge is a condominium development, and the Homeowners Association was having a meet the candidate forum on a Sunday, April 17, 2011, more than 2 years ago. And Officer Taylor showed up there in uniform. But Officer Taylor had his radio on. There's an evidence of this. Officer Taylor asked another candidate at that forum. They had them all sitting in a line of chairs up towards the front. He asked that candidate, he said, could you move over? He's got a radio injury, I may have to take a call. And as it happens in police work, we often have officers that are on duty doing all kinds of things. We got an assistant chief that gets paid to coach football at Aurora, not even here in Lawrenceburg. We got officers who got kids playing sports and they're on duty and they go to games. We got officers who nothing's going on, there's no radio calls, there's nothing to do. They might sit in a restaurant for 2 hours and have lunch and get paid for it. We got officers who got kids graduating or relatives graduating, and they go to the graduation exercise while they're on duty, and they put in time and get paid for it. So that's nothing new. And I think it's okay that we let our police officers go to their kids' games while they're on duty. After all, a lot of policing is just being out there in the community. Officer Taylor was out there in the community. He was at a political event. They had issues with the city. He's a city police officer that's in the city limits. So you can call it dishonest criminal activity. And I don't want to get too technical on the mens rea required to prove various crimes. But what Officer Taylor always said, and the chief, the assistant chief made a record of it, was it was an honest mistake. He wasn't even thinking about it. But he wasn't supposed to be there in uniform. We don't dispute it. He was there for 2 hours and 11 minutes, the investigation reveals. And so Doug made a mistake, and I'm not surprised. Doug's not Superman. None of us are. We all make mistakes. Lord knows I've made them. I got a daughter back there that'll give you a laundry list as long as this council chambers in fine print. And I know you've all made them too, because like Doug and like me, you're human too. And the question is, what do we do about that? Making those kind of mistakes doesn't make Doug a bad man. My mistakes don't make me a bad man. Your mistakes don't make you bad. It makes you human. When Doug learned that he did make a mistake, and again, we don't dispute that it was criminal, he did the right thing. He was at that event on April 17, 2011. That was a Sunday. Monday there were meetings here in this very chambers. And after the meeting, his political opponent, Mario Todd, pulls him into the back room with the chief. The chief had been taking calls about this incident all day long. And they confronted Doug about it. And Doug was shocked and surprised. He never thought of it. And that's what he told him. He admitted that he did it. He apologized. A week later, on Wednesday, April 20, on Monday, April 25th, 2011, the chief, the assistant chief, sat Officer Taylor down, asked him about it. Again, he admits it, didn't shy away from it, and he got reprimanded. There's a record of that signed by the chief and the assistant chief. It's in his file. So in that regard, Doug did the right and honorable thing. It's what we teach our kids to do if you make a mistake. Fess up, make it right, go on. It's what our parents told us to do when we make a mistake. Don't lie, try to avoid, be forthright, be honest. And Officer Taylor was. And you can say that's not the kind of person we want in our department. I'm going to beg to differ and tell you, I, as at least a business citizen of this community, that's exactly the kind of person I want in our police department. None of those guys are Superman. None of those guys are above making mistakes. The other thing I can tell you, and this is interesting to me, Mr. Dilts says we don't want officers that break the law in our department. That's rich, because you all know who they are. Jeremy Shepard beat a woman up in front of her small children. State police investigated. Everybody's got the same story except Jeremy. She fell down the steps. Went to the prosecutor. Jeremy got charged with disorderly conduct. He pled guilty. He should have been charged with worse. And we'll present evidence. He got charged with disorderly conduct. He pled guilty. He's admitted committing a crime. He's convicted of a crime. And he works in the department for this man, where his attorney says, we don't want officers that break the law in our department. Young Troy Cochran, convicted of at least 2 crimes that I know of. Hired by this man, works in the department. Those are folks in the department now that were convicted of crimes. Doug's never been convicted of a crime. We won't know ultimately whether he gets convicted or not, but I suspect that he won't be in April 14 or April 1, 2014. The case will be dismissed. But be careful, because I do think it's problematic for you all, and it's really problematic for the people of Lawrenceburg who ultimately get to pay the tab if you screw up, when you start treating similarly situated individuals differently. And because you've got these other folks in your department that have been convicted of crimes, no action being taken against them, like Mr. Taylor, sort of reinforces what we're saying. This looks vindictive. This looks retaliatory because he accused you all of committing crimes. And don't let this point be lost. We'll show you that Doug's already been disciplined for this conduct. Chief met with the mayor. It wasn't you, Mr. Mayor, it was your predecessor. Then they had the meeting with him, with the assistant chief, reprimanded him. And we've got policies and procedures, the SOPs, although again, we can test whether those are accurate or not, maybe they aren't, maybe they aren't. We've got an employee handbook, we've got a union contract. They all talk about progressive discipline. It usually starts with more reprimand, that's what he does. He's got a good, clean record. We've got his personnel file too, and you get to see that. 22-year police veteran with a nearly pristine record.
You got 2 minutes, Mr. Butler.
And so it looks like to us that there is bias, there is prejudice, it is retaliation for blowing the whistle. We think it's again bolstered by the similarly situated folks convicted of crimes. He's not convicted, won't be under this agreement, being treated differently. And again, all that, when you go treating him different than others, gets potentially expensive. I think you all know Mr. Taylor was involved in a whistleblower suit in the past. My understanding, I don't know, that's confidential, but I understand through the grapevine that cost this city $1.25 million. That money would have done a lot of good for the citizens of this community had the city not messed up and not had to pay that money. I don't want to see that happen here. Officer Taylor's a 22-year-old veteran, wants to keep his career. I hope you'll find it for him. Thank you, gentlemen, for your time.
Is the board ready to proceed with the evidence?
This board should,
Break. Hour and a half.
a break, you want
The
to
time
come
to
on?
break? Short 5-minute break.
I'm good.
I'm going to call, excuse me, I'd like to call Aaron Negengard.
I'd like to make an objection whenever you indicate the appropriate time is, Ms. Votel.
You want to do it now, or you want to do it after I bring him in?
How would the board like to proceed? Do you want Mr. Nagengarten in here for the objection, or do you want?
It doesn't matter to me either way, whether you bring him in or we do it now.
Go ahead, Mr. Butler.
My objection to our prosecutor, Aaron Negengard, as witness, is the March 27, 2013 statutory notice that you were required to give. And according to the SOPs attached to that notice, and does everybody have that, by the way?
I can definitely.
At March 27, 2013 notice? Not bear with me. I'll put it in the evidence.
I have a copy.
Mr. Dilks, I'm bringing you a copy.
Oh, thank you.
did you want one?
Yeah.
I got an extra if you want it. You can keep track of what's going on. Leslie, I think we agreed previously how we were going to mark these. How do we mark them?
You would be 01. And before you proceed, Mr. Butler, I do believe this was one that was already raised at the previous hearing.
I think it was, but I think there's... Yes. No problem. We'll wait. And again, if you take a look at that March 27 notice that you're required to give me, and you take a look back on page 2, page 2 says we got the SOPs attached, and that form, SOP form that Mr. Dilch put in, a C2 or 3 or 1, whichever it was, says this form, along with the applicable pages of the SOPs, the aforementioned deferred prosecution agreement, and the probable cause and information filed in the criminal matter, is the extent of the evidence to be presented for consideration by the Board of Public Works and Safety at your termination hearing. So, gentlemen, understand what's going on here. You're required to give me notice. Your lawyer did that. And it says, here's all the evidence that you're going to be confronted with. Nowhere in there does it say Aaron Negengard. Now, if you're calling Aaron Negengard solely for the purpose of authenticating and introducing into the evidence these records, we'll stipulate to these records. If you're calling Aaron Negengard to do anything else, you have violated Captain Taylor's right to due process. Because due process means we get to know the charges against us so that we can prepare a defense. And you can say, I'm going to call Aaron Negengard. I was advised before this hearing that you're going to call Aaron Negengard. I have an idea what he's going to say. And if you look at the SOPs attached to this exhibit, somewhere in there it will tell you that you are required to tell me what the evidence is. And that's precisely why your attorney, when she sent me the notice required by statute, put that information in there. She was complying with the law. It's not now fair to Officer Taylor to call other witnesses. We have no idea what they're going to say. We have no ability to prepare to defend against his testimony.
Mr. Diltz, can you respond to that?
I do believe that this was already addressed at the previous hearing, and whatever arguments I made at that hearing, which I'm sure were awesome, I would like to reincorporate again. But because I've forgotten what it was since then, I'm going to reiterate that on April 18, I sent Mr. Butler an email advising him and providing him with the exhibits I intended to introduce at the hearing, and I also informed him that I intend to call Aaron Negengard, Chief Hunfeld, and possibly Mike Lanning as live witnesses at the hearing. I don't know what other blindside could possibly happen. We've been here once before. Mr. Negengard was here before. I assume Mr. Butler saw him at that time and knew that he was going to testify. But I didn't hear any such objection about the SOPs at that time either. He's not here merely to authenticate records. He is here to provide substantive evidence. I believe that the written notice provided on March 27 was specific to the documents, because at that time it hadn't been determined which live witnesses may be called, which is why I supplemented on April 18, just a few weeks later. So I believe that Officer Taylor and Mr. Butler have had ample opportunity to be advised of who was going to be here and that they were going to testify. And as for the balance of the guesswork into the testimony to be provided by those witnesses, I'd say that due process runs both ways, in that I have no idea either who Mr. Butler is going to call, what evidence he's going to tender, or what those witnesses are going to say, as I've not seen any of the subpoenas from Mr. Butler. I wasn't copied on any of them to whomever they may have been directed. So I think if we're interested in a full, fair, and impartial hearing, that's kind of important. So I guess to put it in layman's terms, what's good for the goose is good for the gander.
And I would acknowledge the attempts and acknowledge that that there were at least 2 emails where Mr. Dilts asked, who the witnesses and exhibits were going to be from Mr. Taylor's counsel. And I think the final answer to that was he wanted to hold his cards closely, that he did not want to divulge to the other side who he was going to call. Although I think Mr. Dilts, he's holding him to that standard. My opinion on this is that both parties should be able to call who they want to call. We gave notice, the notice that we were supposed to give as far as the original charges and what we were hoping to have, present at the hearing through further investigation and talking actually with Mr. Nagengard. There was more evidence that was pertinent and relevant and material to this hearing. So I do think that his objection should be overruled.
Highlights the problem. There's more evidence pertinent to the hearing, but you didn't tell me. And the difference in my not telling and Dilts or this board not telling.
But he did tell you on April 17th, Mr. Butler.
That Aaron Nagengard would be a witness. If
Yes.
you want to slap a sticker on Nagengard and introduce him into evidence, slap it over his mouth, because I don't want to hear anything he's got to say.
Okay.
Put him in evidence, make him exhibit. What you didn't tell me is what the evidence is going to be. You told me who the speaker is going to be, who the witness is going to be, but not the evidence. And gentlemen, I didn't hand this out for fun. Look at page 32 towards the back. Because what your counsel isn't telling you is what it says. And what it says is, you've got to give me a copy of a summary of evidence supporting each charge. That's in paragraph 4, the very end of it, up at the top of the page. You got to not just tell me who your witnesses are going to be, you got to give me a copy of a summary of evidence supporting such charges. You did that on March 27th. That's where at page 2 you said, it's just going to be these papers. And then you told me there's going to be some witnesses, but you didn't tell me what the evidence is. Now, if the witnesses are your evidence, again, slap a sticker on them, put it over their mouths, I don't want to hear from them, and introduce them into evidence. I won't object. But I do object where your own policies, and by the way, you're looking at terminating this man's job for violating these policies, but yet you're standing up here and your attorney's telling you to stomp all over it. We don't care what it says. Because you didn't tell me what the evidence is. And your policy very clearly says, you're a smart gentleman up here, you can read it, you got to give me a summary of the evidence. So you want to give me a summary? Show me it. Never got it.
How would the board like to proceed on this?
I think both ways. I think you're privy to, you should be privy to what Mr. Butler has and vice versa. I don't disagree there, but in both directions.
Mr. Brenner, let me speak to that, and I appreciate it.
No, Mr. Butler, we're discussing this among the board right now.
All right. I'd like to
Thank
be
you.
heard when you get finished.
Go ahead, Mr. Cook. What's your opinion on this matter?
I mean, like he said, what's good for one side is good for the other. I mean, if he's got witnesses and he doesn't know what they're about, I mean.
And Mr. Bryant?
I'm polled. It is in number 4. I think what's good for the goose is good for the gander also, but it's right in our policy. I would ask your legal advice.
So then, anyone that Mr. Dilts didn't get should be scratched, I mean, that's the thing, is we're here to hear everything. I don't want to come back.
I don't want to come back either, and Nagengard was here at the last hearing, and he was fully aware that he would be here at this one.
Gentlemen, the
I
problem
think
with
it's a
the what's good-
communication error.
Excuse me, he's talking. Go ahead, Donnie.
I'm done.
Sorry for the interruption.
Any more to the board? Anyone proceed?
Again, could I be heard regarding the what's good for the goose is good for the gander argument?
I think if we continue to have every point back and forth, I think they know what the issues are here on this, on your objection.
Of the adversarial process is to enlighten the position of the decision.
I understand, and I've
there
stated
is
what
a
the
good,
position of the
valid
board
legal
is.
reason why the what's good for the goose is good for the gander rationale is not appropriate.
Do you
And that is-
still intend to call your witnesses, Mr. Butler?
Both of us, and you all as well as a board, are governed by procedures that are spelled out for us. And those procedures require that you all give me a summary of your evidence. And by the way, you all passed those procedures. You all made them up, or the chief made them up. Again, we didn't make them up. We're just bound by them. But nowhere in those procedures does it say, I've got to disclose my witnesses or my evidence. If the procedure required that, I'd certainly do it. We're all bound by the procedure. So that's the trouble and the fallacy of what's good for the goose is good for the gander rationale. We've all got to follow procedure. They didn't. There's no requirement that we show our evidence.
Again, what you cited from the SOPs, Mr. Diltz, the SOPs do state with a copy of a summary of evidence supporting such charges. Right there it says this is summary, Mr. Butler.
The summary is Aaron Negengard.
Well, there's a summary of evidence supporting
not
such
his-
charges.
that's
And
not
that's
his-
what I gave you on March 27th, was a summary of the charges. And actually was more specific than I think even the statute, the 36834, requires. So,
You told me what the charges are on the March 27 letter. And you
a
also
summary
gave
of
me-
the evidence.
And you also gave me a summary of the evidence. That's on the
According to the
second
charges.
page of the March 27 letter.
Correct.
And your policy says you got to give me a summary of the evidence. Now,
Correct.
again, you haven't given me a summary of the evidence if you just told me Aaron Negengard is going to be a witness. Unless, again, you're going to introduce him and put a sticker on him. But what you want, and you've said yourself, well, we've discovered new stuff and it's pertinent. We are completely dumbfounded and blindsided. We don't know what it is.
you've
We
known
know
since April 17th. You've known
No.
since April 17th that
that
Mr.
Aaron
Negengard-
Negengard was going to testify.
Yes.
I don't know what's in his head. I don't know what you've discussed with him. You didn't invite me to the meetings. I don't know what he's going to testify to.
Okay.
Certainly, I knew he was going to be a witness.
Okay,
But we
we've
don't know
heard,
what
we've
he's-
heard your objection, Mr. Butler.
At this point, I guess I'd like to observe that the statutory proceedings and the SOPs provide for a summary, not a disclosure of all evidence. There's no discovery proceeding here, which is why I don't know who his witnesses are. That's why he doesn't know what my witnesses are going to say, other than they're going to discuss the charges against Officer Taylor, which stem from his admission and confession of the probable cause affidavit and information in his criminal case, as outlined in the March 27 letter. What Mr. Butler would have the board do is impose a great deal of extra form that's not spelled out in the SOPs or in the statute, and create these hoops to jump through that aren't spelled out anywhere with any specificity in any of the statutes, regulations, or SOPs associated with these proceedings. I think that's an erroneous approach, and for that reason, we would object to that.
How would the board like to proceed?
Aaron?
Going with what Mr. Diltz said and the fact that Mr. Butler's known about it for at least 4 months, I would like to allow Mr. Negengard.
Paperwork, obviously dated that, and that he was here last meeting to testify. I would say that they were aware of him testifying.
Tommy?
With the legal counsel's advice, I'd go ahead and bring Mr. Negengard on.
Before I bring Mr. Negengard in, let's take a 5-minute recess.
Well, it's
Long time.
You remember about the loan on the false information, and then you want to tell me about this?
No, I'm going to tell you about my rights.
No.
You have no right to do that, Mike.
I got a
And
right,
No, I
freedom of
told you.
speech, and I'm going to use it.
Well, you do that. You run your mouth
Hey,
as much as...
I'm glad that I don't have to get my mom when you come to these meetings and fight for me and stick up.
Nobody, this is about Cheryl.
Yeah.
This is not about Bill.
Well, I got a city document
I talked
that showed the
Mr.
numbers.
Lilly.
I can't
And
help
he
it.
said to me, if you had that information, you got it illegally. You didn't get it from him. Because that's a violation.
I don't know who
of my
Mr.
rights.
Lilly is.
Well, then obviously, you don't know too much. Yes. He's the city. You're the city.
It's a city record. It's public record. The city owns it.
It does.
Public record.
But if you have a question in regards to me, you need to...
Public record. Public record. No, let me see how people act around Lawrenceburg.
No, I asked him a question about loud. You're the one that got loud, Mike. I didn't. I simply asked you a question while you were discussing it.
I did not say that. What I said was what the paper showed. It's a city record.
And that's
Maybe you
fine.
ought to go over and take it up with the city.
I don't have to take it up with the city. I have my receipts that validate that.
All I can say, it shows the amount you're supposed to pay on the paper, and it shows the amount you pay.
Right.
That's
And
all
when
I
my
can tell
husband
you.
died, that house increased.
Well, they ought to fix the paperwork then.
Well, you're a councilman. If you own the city, aren't you in the best interest of the city?
Yes, I am not the record keeper. I'm not the record keeper.
Nobody seems to want to know about the record without getting further.
That's why they're called public records.
Well, then why don't you get forward correct knowledge of that record?
Oh, so you're saying that our clerk treasurer?
I'm not saying anything at all.
He asked for an investigation.
I'm just asking you a question.
All I can do.
Then he asked for, and I don't, you know, with respect to that,
That's how I can say.
I can tell you that I talked to Mr. Johnny today. He said if you had any
well, I
questions.
filed a motion to quash because this is working.
I signed a contract.
I don't know if Mr. Willie ever sit down and talk about it, but the law says the official record keeper is the clerk treasurer, and if you want to know anything, that's where you go. They don't say, go contact Mr. Willie. It says it's clerk treasurer,
You know what?
the official record.
Whenever I have a comment about it, I just ask a question.
Oh, yeah, you done a lot of it. Well, now it's okay. Good seeing you, sir.
And you know what?
I'm here to do it. I'm not hiding nothing.
Why do you?
Man, you know how many calls I've had about what you said about me? You know what? You know what I said?
You know how to.
You know what I said? That's right. You know what I said? As long as you're talking about me, you're leaving somebody else alone.
You know what? Nobody discusses it.
Good. I don't care. You don't have to lie.
I don't.
Thank you, man. I'm glad you don't.
Let me tell you something.
Monday,
When you're
Judge
not talking about these council
said this had to be a
people,
public
you're talking about
hearing
me
instead of an
in the
executive
parking
session.
lot, and I don't
So it's open to the public.
I said what a public record said. You remember what I said about my loan and everybody, people wanted to take stuff? You know what I said?
I think Mr. Schneider on that intention of public record. And neither am I. I told you right there, I told you my life is over. So if you have a problem, you should come see me.
Well, you remember that one question Jane asked about when the trailer got bought over
He
there?
is going to, she already just heard about whether or
No,
not
I
the
need
is going to be able to
Nick right here.
testify or not.
Look at the minutes.
Because Nick has other information about what came out in Doug's testimony that they want to Yeah, but this is Richard Arnold. Well, it was actually a negotiated plea, so it wasn't a negotiated plea.
Yeah.
That's 3 months ago.
I don't know which one you're on.
Dr. Zaharica, do you know Bruce LaGore? Dr. Peter
If you would. Okay. Now it's a job. Very different. It was a feeling. More in your notes. I was giving that one to Eric.
No, these. Yeah, because you talk about that, yeah. Because it's a public meeting.
All right. I think everything's picked up,
He didn't nominate. I'm always surprised that I've been over here racing. Let's remove the commercial bids. 30 years, 22 years. So I know most of the people in Lawrenceburg. Yes.
At my spot.
I'm not on the motorcycle, I race Which part of it
It's just like you.
It'll work with that one. Nice to meet you, Doctor.
Oh, yeah. That's fine.
Am I ready? I'm ready, Your Honor.
Call this hearing back in session.
I'd like to call Aaron Egengard. I assume he needs to be sworn.
Yes.
Rainey, please, do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. You state your name, please.
Aaron, Aaron Egengard, Negangard.
What's your occupation?
I'm the prosecutor for the 7th Judicial Circuit encompassing Dearborn and Ohio County.
And as part of your occupation as the prosecutor, do you rely on information submitted to you by police officers in order to effectively perform your job?
I do.
How does that work, please?
Well, police...
Basis of the objection is basically the same as previously made. I believe your own policies, the ones you're seeking to terminate Officer Taylor's employment for violating, say you've got to provide me with a summary of the evidence, and I've never heard before that this was going to be into evidence.
Your
Is that the
obje-
same response?
Your objection is noted, Mr. Butler.
And in the interest of brevity, could we note my continuing objection to any further questions?
Sure.
Your objection is so noted.
Thank you.
Could you repeat the question?
Yeah, how is it that you incorporate information provided by police officers to you as part of performing your job?
Well, generally, police officers will conduct an investigation, depending on their position, whether they're a detective or a road officer, that encompasses different things. They'll communicate, prepare a report on the findings of their investigation, and they'll submit it to us for review. Generally speaking, that's how it works. In any sort of major investigation, I often consult with detectives while the case is ongoing to make certain we're getting the correct evidence and that the laws are being followed with regard to the Constitution. I also will, a number of charges are generally filed without review by our office, or not filed, but presented without review. For example, if an officer conducts a stop, arrests somebody that night for, let's say, an operating while intoxicated, then the officer will prepare a probable cause affidavit, sign that affidavit under oath, and will attach an information, and then we review those charges either the following Monday, sometimes on Sunday, or the following day if it's through the week, and determine if there's sufficient evidence for probable cause, submit that to the court makes that determination. But that's done without sort of any review, and the rest is done on the spot. Since I've become the elected prosecutor, it's been my policy for officers to meet personally with us to discuss cases that they investigate, to make sure we have everything prior to filing a case. It's my belief that cases generally get the idea is to have the best information possible prior to filing, so that's a policy of mine. It's also a policy if they do a warrantless arrest on a major felony, which we consider murder or A, B, or C felonies, that I be contacted, or the on-call prosecutor be contacted over the night to review whether there's sufficient evidence in that case and anything else that might be done, and that's to ensure that those serious cases are dealt with in that manner.
If you have an officer who has admitted to criminal activity, and in particular a crime of dishonesty, does that affect your ability to be effective in doing what you do?
Tremendously.
How is that?
Well, there's several rules of evidence that apply that would make it a problem. For example, if I were to, if a officer were to have admitted to criminal activity, I would be required. There is such thing as called the Brady Rule. The Brady Rule is rules of the prosecutor is, for example, if you're a defense attorney and your client tells you he did it, you're under no obligation to disclose that to the state. In fact, you're under an obligation not to disclose that to the state. However, if I have evidence that helps the other side, I have an affirmative duty to provide that to defense counsel. So in any case in which an officer is admitted to criminal activity that would include a crime of dishonesty, I would be required to provide all of that information pertaining to that act under the rules of evidence and under Brady. In fact, my law license would be in jeopardy if I didn't provide that information. And so an officer who's admitted to criminal activity, for example, let's say an officer who's admitted to criminal activity is the first to show at a murder scene and provides valuable information at that would be that person. Then my case would be tainted from the beginning, regardless of that person's whether that person was telling the truth or not, because I would have to disclose to that person was involved in a crime of dishonesty, and as such, that person would be subject to cross-examination on that matter. So, as a result, it very much hinders the ability to prosecute any case if a police officer has admitted to a crime of dishonesty.
Is conversion a crime of dishonesty?
It is. In fact, if I could have just a moment, I believe I have a case site. I believe Falsouth, F-A-S-S-O-U-T-H versus State, 525 Northeast 2nd, 318. It's Indiana Supreme Court decision from 1988. Has found that theft or any and lesser included crime of theft would be considered a crime of dishonesty, and conversion is a lesser included offense. In fact, it's the only lesser included offense of theft, unless the theft involves an amount over $100,000, and then there's C felony theft, D felony theft, and conversion.
At some point, did you advise the Lawrenceburg Police Department that because Officer Taylor had admitted to the crimes that he's admitted to in his deferred prosecution agreement, that you are no longer willing to accept information from him?
I did. I believe I was contacted by Chief Hunnefeld or a representative of the Lawrenceburg Police Department, I can't recall, and asked if I would be able to accept information from Doug Taylor because he admitted to criminal activity under his deferral agreement, diversion agreement. And I indicated, after reviewing the records to understand what his admissions were, I indicated that I would not be able to accept information on behalf of Doug Taylor because, you know, I have an obligation. My first and foremost obligation to prosecutors is to the truth. And I cannot have a police officer in any degree who has admitted to criminal activity involving a crime of dishonesty. I cannot have that person involved in a case and ruin a case or taint a case. My job's hard enough. It's very difficult to get 12 people to agree that someone is guilty of a crime beyond a reasonable doubt. These crimes are very serious: murder, child molesting, drug dealing, crimes that affect the safety of the citizens of this county. And I can't afford to have to spend extra time because an officer has admitted to criminal activity. And that's been my policy since 2006, that anyone who's admitted to criminal activity as a crime of dishonesty, I have refused to file charges. And as the elected prosecutor, I'm the only one that can file criminal charges in Dearborn and Ohio County, and that has been my position, and that is my position.
So you stand by that position today?
Absolutely.
At some point, did you receive a letter from Officer Taylor accusing various city officials of criminal activity?
I did.
And did that letter ask for an investigation?
It did.
And what was your response to receiving that letter?
Well, my response was that this information had already been provided to the FBI and the Indiana State Police, and that if they were to present that matter to us for prosecution, that I would review that at that time. Without getting into the details of the letter and the specific allegations, that was my response. Was also it was my understanding that at least that there was an awareness that these items had been provided to the FBI, and I was actually out of the office when these documents were dropped off, and I also indicated that because these documents came from someone who's admitted to crimes of dishonesty, I cannot consider them, and I'm not requesting an investigation, but it's also due to the fact that it's my understanding there was an investigation already in place.
At any point, were you contacted by the state police or the FBI or any other law enforcement agency and asked to undertake a prosecution based on the content of that letter?
No. What is in fact the case is that I have spoke to the Indiana State Police and the Assistant U.S. Attorney regarding an investigation being done in the city of Lawrenceburg. I've not been advised to the details of the investigation, and it's my understanding that when their investigation is complete, that we will sit down. I'll be apprised of that, what they've determined through their investigation, and we'll make a determination what would be prosecuted in federal court and what would be prosecuted in state court. And that's been my understanding since the time they began this investigation. But to be clear, I was advised they began this investigation long before Mr. Taylor's letter.
To your knowledge, has anyone to this point been arrested or indicted related to the conduct outlined in Mr. Taylor's letter?
Not to my knowledge.
I have no other questions for you. Thank you.
Mr. Butler?
Good evening, Mr. Nengard.
Good evening, Mr. Butler.
Good to see you. Feel free to call me Richard. If I slip and call you Aaron, please forgive me.
You can call me Aaron. You can call me Aaron, Richard.
Thank you. I appreciate your obligation of truth, and consistent with that obligation, tell me, you don't like Captain Taylor, do you?
I do not have a favorable opinion of Mr. Taylor.
Okay. And in fact, when he sent you that letter, and let's make sure we're all referring to the same letter. This letter you were referring to in response to Mr. Doak's question.
Without reviewing the attachments, it appears to be a copy of the letter that was sent to me.
And Officer Taylor, or Captain Taylor addressed that to you, correct? Delivered to your office?
He did.
And you didn't respond directly to Officer Taylor, did you?
No, it's my understanding he was not a police officer at the time.
Well, did your understanding he was a citizen of Lawrenceburg at the time?
Yes.
And he didn't even merit or warrant the respect of a response, did he?
I gave a response.
You didn't respond to Officer Taylor's letter, did you?
I responded in the manner that the letter was first given. I believe there was a press release issued pertaining to the letter. The letter was not given to me for purposes of, as I could tell, for purposes of conducting an investigation, but for purposes of publicity, so I responded in kind.
You put out a press release.
I did.
Officer Taylor sent you a letter, though, and you didn't send him a letter back, didn't tell him anything.
No, I did not.
And the other day, this week, Officer Taylor and I and Mike Lawrence ran into you crossing High Street, didn't we?
We did.
And we greeted one another, how we usually do.
We did.
You shook Mr. Lawrence's hand. You didn't even acknowledge Captain Taylor, did you?
I did not.
Your office gets a lot of support from the city of Lawrenceburg, does it not?
It does.
Can you please describe to the board the support your office receives from them?
I receive, well, do you want to be more specific? I mean, as far as financial support or?
Well, it's my understanding that maybe they provide a office for the Special Crimes Unit, maybe they provide a couple of Special Crimes Unit officers. And Mr. Nengard, this is what I hear. I don't know these things to be true, and that's why I'm inquiring. I also understand that they provide your office with some money, I think, for various programs that you all deem beneficial to the community. I understand the mayor even proposed to give an additional $75,000 to your office this year. So any of that kind of support. Those officers cost money. If you provided a special crimes unit office, that costs money. If the utilities are paid by the city, that costs money. Just in general, how much support do they give your office?
So, to be clear, you're referring, though, to financial support?
Sure.
Anything that would have a financial benefit?
Yeah, and financial support in kind. For example, they maybe don't give you money to hire a special crimes unit officer, but maybe they've got one in the Lawrenceburg Police Department, and they lend that officer to you. He's kind of at your special crimes unit's disposal.
And I'm not trying to be difficult. Would it be fair if I described how the Special Crimes Unit was formed and the manner in which it's financially supported?
I'm really just interested in how much financial support the city of Lawrenceburg gives you, if you know a number. I'm guessing it's north of $500,000 a year and south of $1 million. I'm betting closer to $1.5 million.
I don't think that's correct. The question, because support is, the Lawrenceburg City Police and I work hand in hand, so...
I don't mean that.
Okay, because, that would be support for my office is, that eventually, I guess, the whole police department's budget could be considered support for my office. If you need, I can explain the Special Crimes Unit, I can explain how it's funded, I can explain the money that's given to, from the city of Lawrenceburg that has been since 2006, if that's what you want me to do.
How much money do they give your office?
They don't give my office a specific amount of money.
Okay. Do they give your office any money?
Again, they support the Special Crimes Unit.
You think my $500,000 closer to $1 million number is wrong? What do you think the number is?
Well, what is, from what time frame?
A year.
A year.
On an annual basis.
On which year? 2013?
Let's say 2012.
2012. In 2012, they provide...
2013 be easier for you?
Either or.
Okay, 12.
In 2012, they provided $100,000 to the Special Crimes Unit.
Is that a cash payment from the city to the Special Crimes Unit?
It's a cash payment into an account by Dearborn County that is then handled by the sheriff, myself, and the mayors of the 3 cities.
Okay. Is there any other cash in 2012 given by the city of Lawrenceburg that you have control or at least influence over?
To my office?
That you have control or at least influence over?
Well, I serve on the board of the Child Advocacy Center, now called the Southeastern Indiana Child Advocacy Center.
Is that a program ran through your office?
No.
Okay, not interested in that. I'm interested in the support they give your office, your Special Crimes Unit.
They gave $100,000 in 2012.
Do they also pay for some police officers that are at the disposal of the Special Crimes Unit?
There are police officers from Lawrenceburg assigned to the Special Crimes Unit, as there are police officers from the county assigned to the Special Crimes Unit.
I think Aurora assigned some as well.
Aurora has a part-time officer assigned.
How many officers does Lawrenceburg provide your Special Crimes Unit?
Nick Beats has been the primary officer assigned from Lawrenceburg to the Special Crimes Unit. Recently, Detective David Schneider and Officer Jacob Jump are now currently assigned to the Special Crime Unit. In the past, for a period of time, Rodney Markland was assigned to the Special
But
Crime
he's
Unit.
not there anymore.
No, it was several years ago.
So there's 3 full-time officers assigned full-time to the Special Crimes Unit?
At this time, yes. And that happened this year.
And they're employed and paid by the city of Lawrenceburg?
Yes, sir.
They get to receive benefits from the city of Lawrenceburg?
Yes, it works often like the DEA has drug task force, and how that works is the DEA will have a person will be assigned as a DEA task force officer. They'll generally be paid for and receive the benefits from that department, and overtime will be paid through by the DEA. It's very similarly constituted. It was designed off of a crimes unit that was formed in South Bend by now Judge Barnes.
Mr. Negard, who controls the Special Crimes Unit?
Myself and the mayors of the 3 cities and the sheriff.
As a practical matter, that mostly means you? You run the day-to-day?
I don't dictate to them what they do.
Do the mayors dictate to them what they do?
The department heads still control what they do. They're assigned a particular task. Some are assigned to narcotics investigations, and some are assigned to child crimes investigations. And as charges come in, they investigate those charges. They don't work for me.
Does the city of Lawrenceburg provide you with an office or a house?
They do.
The Special Crimes Unit?
They do.
Does the Special Crimes Unit pay for that out of the $100,000 that was given to them last year?
We do, but it's a nominal fee.
What is the fee?
$1.
Okay. And who pays the utilities and maintenance on that building?
We do. Comes out of the money from the...
The Special Crimes Unit pays
Right.
for that? Okay, so you get a monthly electric bill, you pay it.
Yes, sir.
Does your office get any other financial support from the city of Lawrenceburg?
My office, other than it's varied from year to year, but in 2012 it was $100,000.
Was it $175,000 this year?
It was $175,000 this year.
You know why that went up?
Mayor Carr indicated he really appreciated the program. I believe all the members of City Council at the time indicated their support for the work the Special Crimes Unit was doing and agreed to increase the funds.
Mr. Nangard, was that before or after you received a letter from Officer Taylor accusing all those folks of crimes?
I can't recall because I believe Mr. Carr indicated his willingness to increase the funds from the time he was elected. Once he got elected and we had a meeting, he said, I think you guys should have $175,000. I believe also that other members of council, a majority of the members of the council who I spoke to expressed the same intention. So I can't speak as to when that $175,000 was increased.
Might have been after Officer Taylor sent you the letter. You put out the press release says, I ain't going to look at these guys.
It could.
Okay.
It could have been. I didn't issue a press release that said I'm not looking at these guys.
Well, what would we mark this?
02? Was 01?
I'm going to mark that 02, the letter from Taylor to our prosecutor. This would be 03. I'm going to show you now, we mark for identification purposes as Exhibit 03. Is that your response to the letter you received from Officer Taylor?
It is.
So you didn't say you're not going to look at these guys, but you did say this office will not waste any taxpayer money by taking any further action at this time.
I did say this office will not waste any time by taking any further action at this time.
And I think you told me earlier it was partly because he'd admitted to a crime of dishonesty.
Partly.
What if somebody else brings you that complaint? What are you going to do with it?
Well, Mr. Butler, the fact of the matter is, as you're well aware because you've spoke to the investigators, there is a criminal investigation pending at this time, and through the FBI and the Indiana State Police. And what I do is I tend not to want to talk about investigations that are being conducted in public because it tends to hinder the results of those investigations. So why I am not wasting any taxpayer money by myself taking any further action at this time. The FBI and the Indiana State Police, I believe, are investigating every allegation, including almost anything that's come in under the sun, including additional allegations on Mr. Taylor and others. And so that's what I meant by that, is that we're not going to respond to Mr. Taylor specifically by giving his allegations any merit. That investigation is being conducted. If the Indiana State Police and the FBI present me a report articulating crimes that anyone has, I will do what I always do in that, and I will see if there's enough evidence to pursue those crimes, and if there is, I will charge them. If there are individuals whose relationship I am too close to, I will file and get a special prosecutor. But until I know who the targets are, until I know who is going to be part of those charges, it would be premature for me to say I can't look at the case.
Tell me this, because I didn't understand that from your earlier testimony in response to Mr. Dill's questions, and I don't understand for sure yet from your soliloquy just now. Is it your testimony that the U.S. Attorney's Special Government Corruption Task Force that you alluded to me having talked to is investigating the allegations in Officer Taylor's letter to you?
I don't know if they're investigating the allegations in Officer Taylor's letter. I know they've issued, let me finish my answer. They've issued subpoenas to the Lawrenceburg. I know they're investigating. I'm not going to get into the details of what I know regarding the targets of the investigation. I know they are investigating allegations that have been made. I know because Mr. Taylor's letter says that he gave copies to the FBI and the Indiana State Police, that the investigators in that case were going to review those allegations and see if there was any merit to them. But so if they review it and determine there's any merit to the allegations and bring me back evidence of criminal activity, then I will take appropriate action, which is why I said by not taking action at this time. There may become a time that action is appropriate. That time is not now.
Okay. I still don't understand. I understand you say that part of the reason you're not doing anything is because the Indiana State Police and the FBI are investigating, but I understood you to say in response to my direct question that you don't know if the Indiana State Police and the FBI are investigating the allegations in Officer Taylor's letter.
I know that they've received it and have reviewed it in the same manner they've received a number of complaints in this matter.
So is it your policy not to investigate complaints of criminal activity that are also sent to the Indiana State Police and the FBI?
No, what is
Just
my...
in this instance, then?
No, not in this instance. In this instance, I have been contacted by the Assistant U.S. Attorney, Sharon Jackson, who's overseeing the investigation.
Okay, this instance, do you mean in response to this letter?
I mean, no, I don't
I'd like
mean...
for the witness to be able to finish his answers before being questioned.
You know what? I'm fine with that. It's interesting, though, that we're not concerned about judicial efficiency of this proceeding when your witness wants to testify, just when I want to make an objection. But I'm okay with that. Go ahead, Mr. Nagar. I apologize for interrupting you.
Okay, well, at this point, I've forgotten the question, Mr. Butler. Could you repeat the question?
Well, I don't know that I remember, but here's the point. I don't want to mince words with it, but I understood in response to earlier questions that part of the reason you're not investigating the alleged criminal activity in Officer Taylor's letter to you is because you believe the Indiana State Police and the FBI were investigating, but then when I asked you directly, are the Indiana State Police and the FBI investigating, you said you don't know.
Okay.
And so I'm concerned that a citizen, although an officer that may have admitted to a crime of dishonesty, of which, by the way, has never been convicted, but that a citizen has brought a complaint to you of serious criminal activity by elected officials, the chief of police, the assistant chief, every member of this board, multiple misdemeanors, multiple felonies, and nothing may be happening with it. And those alleged crimes are costing the taxpayers of this community tens of thousands, if not hundreds of thousands or more of their money. And so, can you tell me, is anything being done, to your knowledge, by you, well, I think you already said no, by anybody?
Here's how I can answer that question, because here's what I know. I know that the police, the Indiana State Police and the FBI were conducting an investigation. I know that you had provided information to the Indiana State Police and the Federal Bureau of Investigation. I know that you were aware of the allegations in this complaint. And so, if you told the FBI and the Indiana State Police the nature of these egregious allegations that you allege,
But you don't know
then if you did, then I would presume they're investigating. I also know that they have been provided a copy of the report, because I did speak of the allegations. I did speak to Tim Denby, and I know that that was to be taken with every other allegation. There's been allegations on every member of the City Council of Lawrenceburg. There's been allegations on you and additional allegations on Mr. Taylor, and I know all those things are being looked at, and that when the investigation is complete, I agreed at times I wanted to take further action. And I agreed with the Assistant U.S. Attorney handling the investigation to wait till the FBI and the Indiana State Police were complete. Their investigation was complete, and then I would do my responsibilities as the elected prosecutor in reviewing those matters for further action. So I am allowing the process to take place in the investigation to continue. I saw your client's actions as a hindrance to that, since it was made public. And that bothers me, because it doesn't appear that the person is really interested or motivated to get a good result if that person believes those crimes are being committed, but is more interested in creating publicity against those he harbors ill will towards. So to the extent that your client interfered with an investigation that was ongoing, I was not happy. And that is why I gave the response I did. And I don't know if anything he says is truthful. I can't take his word on it at this point, but I know that the appropriate authorities are investigating all the allegations that have been made, and when they are done with their investigation, they're supposed to tell me what they determined. As of this date, I have not been advised that they're done with the investigation. In fact, with the exception of additional report provided on your client, I've received no case report of any kind from any agency, any law enforcement agency, alleging criminal activity on anyone other than your client.
So you're not doing anything but cut through the fact because the FBI and the Indiana State Police or the Assistant U.S. Attorney asked you to stand still, they're conducting an investigation?
That's correct.
Okay. And did they ask you to stand still before you put out the press release saying, I'm not going to do anything?
They asked me to stand still long before that, yes.
And if a citizen becomes aware of criminal activity committed in the 7th Judicial Circuit, who maybe doesn't have your intimate knowledge of what the U.S. Attorney, the Assistant U.S. Attorney, the Indiana State Police, the IRS, the FBI are conducting an investigation about, are they supposed to check with them first before they report it to you?
No, but I believe you, who represent Mr. Taylor, were aware that such an investigation was taking place.
Well, I wouldn't be so sure to know what I knew about that investigation. I can tell you that I didn't show up and give him this letter when I met with him. I met with him way before that.
But your client provided copies to both the FBI and the Indiana State Police.
Tell him what they're doing.
Well, but we don't tell people what we're doing with regard to an investigation during an investigation, because that would hinder the quality of the investigation. We investigate, and then we file charges when appropriate.
Now, you said it's your policy when an officer's been or has admitted a crime of dishonesty not to accept charges from that officer. Is that correct?
That's correct.
And has that happened before in your office?
It has.
And who was the officer?
Brett Hamilton of the Aurora Police Department.
Anyone else?
I had issues with Bill Hoffman, and I asked that he not be involved in any major investigation because I was concerned about his level of competence.
Did you do the same with Jeremy Shepard? Is he not to work any cases over a D felony?
I did indicate I had some concerns with Jeremy Shepard as to his handling of evidence.
And is he restricted to D felony or lower?
No, he's prepared charges on every level of felony. I don't know if he's prepared charges on an A felony, but I did indicate some concerns with his performance.
Are you allowed, legally authorized, to refuse charges from a law enforcement officer?
I am legally authorized to weigh evidence given to me. I have sole authority on determining whether charges should be filed or not.
Are you familiar with Indiana Code 33-39-1-4 duties on receiving information of felony or misdemeanor?
I haven't reviewed that statute recently.
It appears to me that that statute makes it mandatory when you're given information of an alleged crime to pursue it. It says shall in that statutory language. And so I'm having trouble understanding how when that statute says you've got to do it, you can just say, well, he's convicted of a crime of dishonesty, that can kind of, or admitted to a crime of dishonesty, that can kind of, that's actually problematic. So I'm not going to do what the statute requires me to do. Can you explain how, in light of that statute, you can do as a matter of policy what you told this board you do?
I'm going to object at this point because I believe that there is an inadequate foundation for any kind of response in that the statute is taken out of context of any case law discussing prosecutorial discretion. I don't further point out if there's an absence of relevance as to whether Prosecutor Negengard's policy is appropriate or not, as deemed so by Mr. Butler. The fact is, he's testified that that is his policy, and whether it's the right policy and whether everyone agrees with the policy isn't relevant to whether he has the policy, which is undisputed at this point, and the basis on which information from Officer Taylor are not being accepted. So those are my objections.
In response, if Prosecutor Negengard's testimony is, and I believe it was, that I'm not going to accept any charges from Officer Taylor because he's admitted to a crime of dishonesty, and that is now, surprise, trial by ambush, a reason not previously disclosed to Officer Taylor and I, but a reason for you all to terminate his employment. It certainly is relevant whether he can legally do what he's saying he's going to do. And he can answer. He's a lawyer. He's a prosecutor. He's very eloquent, very competent, very versed. He's familiar with the statute. He said he hadn't reviewed it recently. I think he certainly answered the question.
Could you please refrain from the sarcasm? I think there's no need for that in this hearing. At this point, the board has heard both parties, and how would you like to rule on that? Mr. Bryant?
I've heard enough.
You've heard enough? Would you like Mr. Nadengarten to answer the question?
No, I don't think he does. He's answered it sufficiently, I think.
What about you,
No.
Mr. Cook?
Yeah, I agree with Mr. Dill, so you can...
We would overrule the objection. Proceed, Mr. Butler. I'm sorry. We would sustain the objection.
Overruling my response.
No, sorry. We would sustain Mr. Dill's objection.
I like the ruling. I was going to ask for an
I'm
answer.
so sorry. I'm not normally a judge, just for the public to know. I'm an attorney myself, so we would sustain Mr. Dill's objection.
Now, when Officer Taylor sent you the letter complaining about the criminal activity of these gentlemen sitting here, the chief of police, the assistant chief, and other elected officials in the city, you didn't ask for an investigation or file any charges.
That's correct.
When you received a complaint that Officer Taylor committed a crime, you did something different.
I did.
Tell us what you did.
Well, at which point?
Well, you ordered an investigation by the Indiana State Police, didn't you?
I did.
And once you got that report from the state police back, you asked for a special prosecutor to avoid the appearance of impropriety.
I did. I'm not certain on the timing of it. I did ask for an investigation.
So you may have asked for the special prosecutor before the investigation was back from the state police?
I may have. I don't recall.
So certainly the complaint about Officer Taylor's criminal activity received from you different treatment than the complaint about these other gentlemen's criminal activity.
It came from a law enforcement agency, and there was documentation to back it up at the time, but yes.
Well, there's a lot of documentation with Officer Taylor's letter too, wasn't there?
Yes, but I didn't file charges immediately, and I didn't issue an arrest warrant immediately there. I asked for the Indiana State Police to conduct an investigation, and at some point, asked for a special prosecutor to review that. And copies of that investigation had not been provided to the FBI and the Indiana State Police at the time.
Did you even review the allegations and the evidence to determine whether there was anything illegal going on?
With regard to what?
Officer Taylor's March 14, 2013 letter.
I reviewed the letter.
You didn't look at the documents to see whether they substantiated the allegations or not?
I didn't look at the documents. It was in front of the Indiana State Police and the FBI.
So it says the city of Lawrenceburg brings to you a complaint of theft by city officials, the chief of police, the assistant chief, and you didn't even look at it.
I looked at...
I'm going to object in that it misstates the testimony. He did look at the letter, and he's already testified about everything that happened with regard to the letter and what actions were taken and what weren't taken afterward. So I think it's also redundant.
Did you not look at the attachments?
I looked at the letter.
There's an objection. Do you have a response to his objection?
Yeah, I'll just change the question.
Okay.
Did you look at the attachments to the letter?
I did not look at the attachments.
Do you have any bias or prejudice towards Officer Taylor?
I don't have a favorable opinion of Officer Taylor.
Okay. You'd agree then you have bias and prejudice against Officer Taylor?
My decision isn't based on my personal feelings towards Officer Taylor. My position is based on the law. That being said, I do not have a favorable opinion of Mr. Taylor.
Do you know whether any of these gentlemen have an unfavorable opinion of Officer Taylor?
I do not.
Also speculation.
No, I asked what he knows.
I don't see how anyone could know inside the mind of anyone else.
Well, I guess he could have asked him a direct question and they could have responded. He either knows or he doesn't. I think he said he didn't know.
I do not know.
But certainly, it's fair to say Lawrenceburg, in some respects, is the hand that feeds your office.
Not the hand that feeds my office, no.
In some respects.
No, I wouldn't agree with that characterization at all.
$175,000?
$175,000 to help prosecute criminals? I don't see that is, I don't see how, let me answer the question. I don't see how $175,000 being spent of riverboat money to assist the taxpayers in protecting the citizens of this county is properly characterized as helping my office. It's my understanding there's been unanimous support by the council for that, and that the monies spent are spent in the interest of catching criminals and in the pursuit of justice. So I don't agree with your characterization at all, Mr. Butler.
But certainly none of that money gets spent catching these folks if they're accused of a crime.
It will if something comes back from the Indiana State Police and the FBI.
No further questions. Mr. Nengard, thank you for your time.
Thank you, sir.
And I apologize again for the interruptions.
No problem.
I'll go redirect. Thank you.
I just have a couple questions. The board can ask some questions. Mr. Nagengard, as far as the...
Hang on one second. Does the pretrial procedure that this board adopted permit you to question witnesses or the board?
I believe it's by the board and board council.
Is that what it says?
Yes, it does.
Where is that?
I will not express an opinion or matter of fact or credibility, and the board will rule on matters such as evidentiary objections raised by the party. I sit basically as a judge, Mr. Butler, and I can ask questions, and if there's anything the board would like to add, I just wanted to bring some things to their attention.
Well, and my question is, I thought I read the pretrial order to permit the board to ask questions. I don't think I saw anywhere where the pretrial order that you all approved permits you to ask any questions of witnesses. And I may be mistaken. I'm looking rapidly. I don't see it. I see questions by the board. Paragraph 11. The board may ask questions of witnesses during the hearing after the representative for each party has questioned the witness. If necessary, each party may ask brief follow-up questions, so on and so forth. I don't see any provision for board counsel to ask questions. I was previously also told that Mr. Diltz is prosecuting this case, not you. You're the lawyer for the board. If the board has questions, I think consistent with your policy, it's appropriate to ask. But again, if this is the policy you all adopted, I don't think you're permitted to ask questions.
Mr. Diltz?
I think as board counsel, you are the voice of the board. So if you want to ask questions, I'm not going to object to it. That said, I don't care who asks the questions. We have no position if the board members themselves want to ask. If you want to ask, it makes no difference to us.
How would the board like to proceed? Would you like to be able to ask some questions of Mr. Nagengard or not? Or does the board have any questions of Mr. Nagengard that aren't clear?
Donnie?
I'd so move if she's got some questions. I'd like to hear them if they're relevant to the case.
Bill?
Again, just express your opinion.
Just ask a question. Any concerning the document?
Aaron? Bill?
Yes, I agree with Mr. Diltz. It doesn't really matter who asks the questions. I mean, the more questions and answers we get, the more information we'll have.
I just have a couple questions, and they're just about the deferred prosecution agreement, as you understand it. I realize that you were not you did ask for a special prosecutor in this case, isn't that correct?
I did.
And that was Mr. Ziegler, is that correct?
Daniel Ziegler.
In paragraph 5 of that agreement, page 2.
Hold on, if I could catch up here.
I have a copy right here.
I have one right here. Paragraph 5, you said?
Yes.
Okay.
It does say the defendant acknowledges, confesses, and admits that he knowingly committed the offenses charged in the affidavit of probable cause and the informations filed herein. Does that include, do you know whether or not there was a new affidavit of probable cause filed with the amended informations?
There was amended informations. The probable cause affidavit was not amended, as I understand it.
Okay. So when he acknowledged, confessed, and admitted to the affidavit for probable cause and informations has an S on the end of it, do you take that to mean the amended informations, the affidavit for probable cause, and the original informations?
I'm going to object. What Mr. Nengard, or Prosecutor Nengard, thinks of that agreement is irrelevant. I'm also going to tell you that, Leslie, you had a Board of Works meeting on March 20, 2013, at which you told this board what he has admitted to are the amended informations. If now you want to go down, try to take Officer Taylor down and terminate his employment because he's admitted some felony informations, again, we don't have any notice of that. I wish you'd just let us know what the evidence is so we can prepare a defense. What you told me by public record, March 20, 2013, Board of Works minutes, is that it was the amended informations. And what you told me in your March 27, 2013 letter was the amended informations. So I don't think it's at all relevant.
Well, when I prepared the March 27th letter, Mr. Butler, I did include that it was an admission and confession to the probable cause affidavit and informations in your criminal case.
And in your March 20 minutes, which resulted in your March 27 letter, you said the amended information. If now you want to make a case to terminate Officer Taylor because he's admitted some felonies, again, I'm going to protest that that's a surprise. You didn't summarize that evidence here, but go ahead. And I object. That's sarcasm. I apologize.
Again, Mr. Negengard, what is your opinion on that?
Well, the deferred prosecution agreement states the defendant acknowledges, confesses, and admits that he knowingly committed the acts charged in the affidavit of probable cause and information filed herein. There was amended information filed as to campaigning in police uniform, a Class A misdemeanor, and conversion as a Class A misdemeanor, and the affidavit for probable cause states official misconduct and ghost employment, which are Class D felonies. As far as my analysis, I take that to mean he's admitted to all the crimes. He's admitted to the facts in the probable cause affidavit, which is, however, my opinion is not based on the fact that he admitted to official misconduct and ghost employment as I read the deferred prosecution agreement. My opinion is based on the fact that my opinion as to not accepting charges is based on his admission, of which I don't believe there's any dispute, that he admitted to conversion. And as a result, that would be admissible under the case law I previously cited and would hinder any investigation to which Mr. Taylor was involved.
Thank you. And can you spell the defendant's name in that 525 Northeast 2nd 318, please?
I can. I have a minute. Fassuth, Fassuth.
Thank you. That's all the questions I have. Mr. Gills, do you have any questions in connection with my questions?
I do not. Thank you.
Mr. Butler?
Ms. Votal asked you if you asked for a special prosecutor. You said yes. She said that was Dan Sigler. You said yes.
Dan Sigler was appointed as special prosecutor.
Did you ask for Dan Sigler?
I did not.
Okay. You spoke to Dan Sigler.
I spoke to Dan Sigler, yes.
When did you first speak to him about Mr. Taylor?
I don't recall when I first spoke to him.
Was it before the deferred prosecution agreement was entered?
I spoke to him before the deferred prosecution agreement was in.
On how many occasions?
I don't recall.
Pardon?
I don't recall.
More than one?
More than one.
And when you spoke to him, was it in person or via telephone?
Spoke to him in person or via telephone regarding this investigation, or spoke to Mr. Sigler in person or telephone?
Regarding this investigation, regarding Officer Taylor, any of that?
Or any time I saw Mr. Sigler? I saw Mr. Sigler at a prosecutor's conference.
I want to know, to try to clarify for you, make it simpler. You said you spoke to him on more than one occasion.
I did.
Before the deferred prosecution agreement was entered about Officer Taylor.
I don't recall how many times I spoke to him. I spoke to him, I don't recall.
Okay.
I spoke to him prior to the deferred prosecution agreement coming into place.
And when you spoke to him before the deferred prosecution agreement was entered about Officer Taylor, did you do so by telephone or in person?
About Officer Taylor, I did so by telephone.
Did you always use the same telephone?
I don't recall. I don't recall.
Would you have used your office phone, home phone, or cell phone, or possibly all three?
I know I didn't use my home phone. I probably used my office phone.
And what did you and Mr. Sigler discuss?
Described the facts of the case to him as I understood him.
The case you got out of to avoid the appearance of impropriety.
Correct.
What else did you talk to him
about? Nothing else in regards to Officer Taylor.
Okay. Did you talk to him about having Officer Taylor admit to conversion so that the very thing that's happening here this evening could happen?
He advised me that that was what the agreement was. I don't know if that was before or after the agreement was signed.
There'd be no reason for him to advise you beforehand. You'd washed your hands up.
As I said, I don't recall. I can tell you that he advised me what the resolution was going to be.
Did you remark about that?
I did not. I did speak to him after I received the letter from Mr. Taylor.
You made reference to that in the press release. That's all I have. I'd move to admit those exhibits.
Any objection to the exhibits?
No.
Mr. Nagengar, just one other question. When was that,
Same objection.
when was that agreement reached, to your knowledge?
I'll further object that the agreement speaks for itself.
Well, I would, it appears that the agreement was reached on March 13th, 2013, the date it was signed.
Thank you, Mr. Questions? Okay, step down. Thank you, Mr. Nagengar.
Thank you.
Thank you for your time, Mr.
Next witness, Mr. Phelps. Or
You want to take a break?
brief moment. Board okay with continuing at this time? Everybody okay with that? We'll proceed.
I call Chief Gene Hunfeld, please. I don't know if you want him to sit or move or here.
He can testify from council table, that's fine.
You solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
You state your name, please,
Gene Hunnefeld,
and what's your occupation?
the Chief of Police for the City of Lawrenceburg,
How long have you been the chief of police for the city of Lawrenceburg?
since August of 2002.
And in your capacity as chief, are you responsible for the management of the Lawrenceburg Police Department?
Yes.
Does that involve evaluating and assessing the effectiveness of the officers you have under you?
I'm object, same objection as to the evidence not previously summarized as required by your own SOPs that you're seeking to terminate Officer Taylor's employment under. Again, they require that you summarize the evidence. This was never summarized to Officer Taylor nor I. Once again, it appears to me trial by ambush, which I think is a violation of our due process rights, and we object on that basis. And if this line of questioning is going to continue, we'd ask that you note our continuing objection on the record so we don't have to make it in response to every question.
Any response, Mr. Delts?
I have the same response I had before.
How would the board like to proceed?
Tommy?
I'd like to hear testimony, carry on.
Bill?
I want to hear the testimony.
Aaron?
Give the testimony.
Oh, yes.
Your objection is overruled at this time, but we will also note your objection, continuing objection.
Thank you.
In your capacity as police chief, does that involve evaluating and assessing the effectiveness of the officers under you?
Yes.
Does it involve ensuring that the officers who work at the department conduct themselves in a way that sheds a positive light on the department?
Yes.
If you have an officer at the department who commits crimes of dishonesty, or really any crime, does that impair that officer's effectiveness?
I would believe so, yes.
Why is that?
Well, public trust is the big issue.
And is it your testimony that the public trust is not served if you've got officers who are committing crimes of dishonesty?
Yes.
And does it impair the public's view of the department if you have such officers who continue to work as officers in the department?
I would think so.
And is Officer Taylor one of the officers employed by the Lawrenceburg Police Department?
Yes.
Is he currently working as an officer?
No.
When did he cease working as an officer?
I don't know.
Does his did him ceasing work as an officer relate to the incident or allegations for which he entered a deferred prosecution agreement?
Yes.
Are you familiar then with his admission in the deferred prosecution agreement to 2 Class A misdemeanors, including one for conversion?
Yes.
And did you have a discussion with the prosecutor about the effect of that admission on Officer Taylor's ability to effectively serve as a police officer?
I don't remember if it was myself or a member of my staff.
Is it your testimony that someone did from your department?
Yes.
And at some point were you informed by the prosecutor that Officer Taylor's information would not be accepted by his office?
Yes.
Has that ever happened before?
No, not that I recall.
It's never happened before.
No.
Does that impair his ability to function as an officer for the Lawrenceburg Police Department?
I think that would be a reasonable assumption.
Is campaigning in uniform conduct that you approve for the officers employed by the department? Is accepting pay while attending a campaign function conduct that you approve of for your officers?
No.
Do those criminal actions constitute conduct that you believe is unbecoming a Lawrenceburg Police Department officer?
Yes.
Have there been other officers who committed some kind of crime but continued on being employed by the department?
Yes.
And were any changes made to the SOPs or any other policy of the department as a result of that?
In 2005, there was a committee formed. They did some updating to the department policy.
Was Officer Taylor on that committee?
I'm not sure, so I don't want to say one way or the other.
When that committee was finished, were there changes made to the policies of the Lawrenceburg Police Department?
Yes, I'm sure there were changes.
Did any of those changes include making violation of the law a punishable or fireable offense?
Yes.
Thank you, Chief.
Your witness, Mr. Butler.
Chief, you don't like Captain Taylor, do you?
I try not to show him any ill will.
I appreciate that, but do you like him or not?
Anyone?
Pardon?
I'm probably not real thrilled with him.
Okay. You kind of share the prosecutor's unfavorable opinion.
Unfavorable, I guess, is an adequate.
Okay. Mr. Dilts asked you, gosh, the prosecutor's never called him before or called the department before and said, I'm not going to take any charges from these officers. You said, no, that's never happened before. Didn't you?
Yes.
But Nangard sat here and told us repeatedly he's got an unfavorable opinion of Taylor. So it makes sense to me that maybe he'd call your department and say, I don't like this guy, I ain't going to take any charges.
Objection. Is there a
Makes
question?
sense to you?
Can you please refrain from all, I mean, he's heard the testimony, he's been sitting here with Mr. Nangard. Please ask the question.
Does it make sense to you that a prosecutor who has an unfavorable opinion of Captain Taylor would say, I'm not going to take any of his charges anymore, so that he can exercise his animus towards that officer and have him discharged from employment?
You're asking me to speculate?
Do you know?
I don't know.
Okay. Are you surprised that a prosecutor that doesn't like Officer Taylor would call you and say, or call your department and say, I think your testimony was, I ain't going to take any charges from him?
I'm going to object in that the question presupposes that the dislike of Officer Taylor predated the decision of Prosecutor Nangard not to accept any more information. But there hasn't been any testimony or evidence to that effect, and so I think it's without foundation.
When?
Mr. Butler,
I'll withdraw the
respond to
question.
that objection.
I'll withdraw the question.
Thank you.
When did your department receive a call from the prosecutor with an unfavorable opinion of Captain Taylor to tell your department that they wouldn't take any charges?
I don't know.
You have no idea?
I don't know the date.
Well, do you recall coming to the March 20, 2013 Board of Works meeting in where it was discussed that we start down this road that brought us here this evening?
I don't know if I was at the meeting or not.
Okay. Did you receive a copy of the March 27, 2013 letter from the board's attorney to Doug Taylor saying, here are the charges against you, here's the evidence against you?
Yes.
Okay. And when did you receive that?
I don't know.
Was it on or about or around March 27, 2013, if you know?
I'm sure it was closed.
Okay. And at that time, had you yet been informed by Prosecutor Negengard that he's not going to accept any charges from Officer Taylor?
I don't know that either.
Okay. Do you know whether the law requires Prosecutor Negengard to accept those charges?
No, sir, I don't.
Do you care?
Objection. Whether he cares or not isn't relevant, especially as it relates to his knowledge of the law, because he's not a lawyer.
Not sure I understand the objection, but here's the point. He should care, and if he doesn't care, convinces me that maybe this is a good way to exercise his admitted unfavorable opinion
Is
of
that your
Captain
response to
Taylor.
the objection?
Pardon?
The objection is that it's
Yeah, that's my
irrelevant.
response. The relevance is he should care, and if he doesn't care, maybe that's evidence of his exercising his unfavorable opinion. Perfect. Here's a way I can get rid of him. I don't care whether it's right, legal, or not. I'm going to get rid of him.
The question presupposes that the chief has some understanding of the law and can express an opinion whereas to care or not care about Prosecutor Negengard's decision to exercise prosecutorial discretion. And therefore, it's not relevant, and it lacks foundation because the chief is not a lawyer.
How would the board like to decide on
Can
this?
I respond to the additional objection?
That's the same, it's the same objection, Mr. Butler.
I don't believe it is. He stated new information.
Go right ahead.
Can you tell me what he said? Please.
The question presupposes that the chief has some understanding of the law and can express an opinion, or has to care or not.
That's not. It doesn't presuppose any knowledge of the law. I don't care if he has any knowledge of the law. He said in my previous question that he doesn't know whether the law requires Negengard to take charges. And my very simple question is, do you care whether the law does that? I don't care whether he knows the law or not. He ought to care when a prosecutor says, we ain't going to take any charges from this guy, whether or not the prosecutor can legally do that.
And there's an absence of relevance as to whether he can care or is in a position to care about what the prosecutor tells him he is or isn't going to do relative to the prosecutor's exercise of discretion. So it's not relevant and it lacks foundation.
I think it's relevant to his bias or prejudice, and I don't think
Board,
there's
how would
any
the board like to
relevance.
review on that, please?
Donnie?
Or do you even understand?
It's kind of confusing. But I understand what the attorney's saying there, that, the chief is not going to run the prosecutor's business and make decisions and care about what the prosecutor does, If he feels the prosecutor's doing something wrong, I'm sure he would seek action or more information.
How do you feel, Mr. Brenner? Mr. Cook?
It's not, I don't feel it's the chief's responsibility to run the prosecutor's office.
Objections sustained. Please move on.
Chief, I'm going to show you on Exhibit 2. Have you received a copy of that letter there on top?
Yes, sir.
And you understand, or do you understand, that in that letter, Officer Taylor accused you of theft from the city, conversion, or maybe at least receiving stolen property?
Yes.
Do you think it's, and did you decide to do anything about that?
Once I was made aware that it had already been delivered by Prosecutor Negengard, I did not.
When you were made aware it was delivered by Prosecutor Negengard?
Two.
Okay. Doug Taylor asked you if you were going to investigate, didn't he?
Yes.
I'm going to jump to 06, is that all right? Who's keeping track of these exhibits?
If I was marking them, I'd be keeping track of them.
I'm going to make this one 05.
Oh, well, can we review real quick what those, we have omitted 1 and 2, 1 being Amy. What was number 1?
I thought we also admitted 3, which is press release.
March 27, 2013.
Okay, so the March 27th letter is 01.
02 is the March 14, 2013 letter from Taylor to the
Okay.
prosecutor.
Okay. Thank you.
And then 03 is the press release from Megan.
03 is the press release from Langenberg. Okay. And can I get a copy of the press release? I don't think I have a copy of that from Mr. Langenberg.
I don't either.
Mark 03 or prosecutor's flagged it.
That's okay. We can get a copy at recess. That's fine.
Let's get to that. Here's 03.
Thank you.
So are we properly up to 04 rather than 05, which is what the court reporter told us in the first place? My apologies. You did a good job. See that? Officer Taylor sent you a letter. Do you recognize that 04 P2?
Yes.
Did you receive that letter from Officer Taylor?
Yes.
And in that letter, he says, hey, what are you going to do about these allegations of this criminal activity I made, right?
Yes.
And you sent Officer Taylor a response, didn't you?
Yes.
I'm sure you wasn't much presentation at 05. Okay. Sounds great. Is that a copy of the letter you sent to Mr. Taylor? Is that a copy of the letter you sent to Officer Taylor?
04 and 05.
Yes.
I'm sorry if you responded earlier. I didn't hear it. I thought maybe you were reviewing it and I was waiting on an answer. My apologies. So, is it normal when a chief of police receives a complaint from a citizen that he's committed some felonies for the chief of police to decide whether there's going to be an investigation?
No objection to that. There's no definition of what normal circumstances might be or that this particular instance fits that description. But
Fair enough. I'll rephrase. Do you have a policy with respect to what to do with accusations that you've committed a crime?
I've committed a crime?
Do you have a policy that tells you what to do if you are accused by a citizen of committing a crime?
Not that I recall.
Okay. Is it, in your opinion, appropriate that you should decide whether or not you get investigated when you're alleged to have committed a crime?
Do I get to decide? No, I wouldn't agree with that.
Conflict of interest, isn't it?
Yes.
And But it appears in your response to Officer Taylor that that's exactly what you did. Is that not right?
I'm sorry, what was the question, Mr. Butler?
It appears in his response to Officer Taylor that he did decide whether or not he should be investigated for having committed crimes accused of Officer Taylor.
I'm going to object in that it misstates the testimony. The letter speaks for itself and doesn't say that, but feel free to answer if you want.
Once I knew it was in the prosecutor's hands, I don't feel that I should supersede prosecuting attorney.
Prosecutor Naggard?
Yes.
Well, isn't it the Lawrenceburg Police Department's responsibility and duty to investigate crimes committed within the city of Lawrenceburg?
Objection. That question lacks foundation insofar as it fails to note that this is a specific allegation against the chief himself and not a mere allegation against someone in the public somewhere in the city
I'm
of
asking
Lawrenceburg.
in general, is it the Lawrenceburg Police Department's duty and responsibility to investigate crimes alleged to have been committed in the city of Lawrenceburg? I thought that's what they did.
If your question is phrased as in general, I will withdraw my objection.
In general.
Not always.
Okay. Not in this instance.
We did not.
Okay. But when you received an allegation that Officer Taylor had committed a crime, you ordered an investigation, didn't you?
No.
You didn't? Detective Schneider wasn't ordered to investigate by you?
I asked that a complaint be followed up on.
Who'd you ask that the complaint be followed up on? Who'd you ask to follow up on the complaint?
Who did I ask to do the follow-up?
Yes.
Detective Schneider.
And he did.
Yes.
And distinguish for me the difference between that follow-up you requested and an investigation.
The complaint was forwarded to Prosecutor Naggard for review.
Before or after you asked Detective Schneider to follow up?
After.
Okay. So you received the complaint about Officer Taylor from a citizen, correct?
Yes.
You asked Detective Schneider to follow up. He gave you a report?
Yes.
And you sent that to Prosecutor Naggard?
Yes.
That's what you did with a complaint about the man you have an unfavorable opinion of. You didn't follow the same procedure when the complaint from a citizen was about you, your assistant chief, the mayor that appoints you, each of these members of this board that control your department, did you?
I believe I already stated, once I was aware that Prosecutor Naggard had the information, it wouldn't be my responsibility to tell the prosecutor what to do.
Well, it's your responsibility, I think you agreed in general, to investigate crimes alleged to have been committed in the city of Lawrenceburg?
I said at times.
Okay. But not when Officer Taylor complains about you, your assistant chief, the mayor that appointed you, or the board of works members that control your department.
I did not ask for an investigation.
Isn't it true that you want Officer Taylor terminated or fired because he accused you, your assistant chief, the mayor, city's board members, and other city elected officials of criminal activity?
No.
Okay. Well, you hadn't heard, and don't let me put words in your mouth, I don't know if you said this or not, had you heard from Prosecutor Negengard that he wasn't going to prosecute or take any cases from Captain Taylor, that for the March 27, 2013 notice Officer Taylor received, which started this.
I don't know.
You're aware, or are you aware, that the Meet the Candidate Forum of the Condo Owners Association at 3 Mile Ridge in Lawrenceburg occurred on Sunday, April 17, 2011?
Yes.
Okay. And the very next day, we had a meeting here at which Mario Todd pulled you and Doug Taylor into the back room here. And Mario Todd made the allegations and confronted Officer Taylor about it.
Yeah.
And by that time, you'd already received a lot of calls about it, hadn't you? That day.
That, sir, I don't know.
Fair enough. Did Officer Taylor admit at that time that indeed he was there in uniform?
Are you speaking with, here with Mario Todd? and
Yes,
myself?
that Monday evening, April 18, 2011, Mario brought you all three together in the room. Did Officer Taylor deny or admit that he was there?
I don't know.
Fast forward another week, Monday, April 25th. Do you recall at that time having a meeting with your Assistant Chief, Don Combs Jr., and with Officer Taylor regarding his appearance at the campaign event on April 17th?
Yes.
And did you or Officer Combs make a record of that meeting?
If you're speaking of this letter, yes.
You did make a record of that meeting? And this letter is it?
Yes.
Okay. And so on April 25, 2011, just 8 days after the April 17, 2011 campaign event, Officer Taylor admitted to you and your Assistant Chief that he was there in uniform.
Yes.
And you knew this Monday night, 7 days earlier, didn't you? Mario brought you in the back room and said he was there?
Yes.
Okay. How do officers get paid? I mean, I assume they don't just get a check. They got to keep track of their time. I assume somebody at the department verifies that the time's right, ships it over to the clerk's office, clerk gives you checks, and you distribute checks. Something like that.
That would be reasonable.
Wait, do you have a procedure to verify the officer's time that they get paid for?
They have time sheets that they fill out usually.
Okay. And does anybody check those or approve those before they get paid?
Right, usually the Assistant Chief handles payroll.
Okay. So, what day do your employees get paid?
They get paid on Wednesdays.
Would that be the same back in early 2011?
Yes, it should be.
Okay. And if they get paid on Wednesday, for what pay period ending date?
If would be from Monday morning to Monday morning.
Okay. Is it Mondays that you collect the time cards?
Yes.
And when do you receive the checks from the clerk?
On Wednesday.
So if Officer Taylor was at the campaign event Sunday, April 17, 2011, he would have submitted a timesheet for that on Monday, April 18, 2011.
Yes.
And he would have received payment for that on Wednesday, April 20.
Yes.
And do you know whether you approved his payment on Wednesday, April 20, or your assistant chief, I think you said was the policy, did so?
It probably was Assistant Chief Combs.
Okay. Never occurred to you when you were pulled into the back room and told he was campaigning when he was supposed to be working that maybe you need to put the brakes on that payment?
It did not occur to me.
Okay. So you wouldn't have told Assistant Chief Combs, watch that one?
No.
But yet, to the extent Officer Taylor was paid for that time, your Assistant Chief approved it. Is that correct?
He would have ran it through, whether he actually approved it or not, I don't know.
Somebody in the department's responsible. You don't just let the officers fill them out willy-nilly and turn them in and get paid, surely. Is that correct?
Right, he checks it and then checks the computer.
Now, it appears from your April 25, 2011 note of the meeting with your Assistant Chief and Officer Taylor that you reprimanded Officer Taylor for his conduct on April 17, 2011. Is that correct?
Yes.
Now, is it true that you've got other officers working for the department that have been convicted of crimes?
Yes.
Who are those officers?
I believe it would be Jeremy Shepard and Troy Cochran.
Is that it?
I'm not sure.
And in your opinion, it's okay for those officers convicted of crimes to be members of your department, but not Officer Taylor, who admitted criminal activity that was never convicted?
I guess you would take it on an individual basis, and it would be on what the conviction was.
Do you know what Jeremy Shepard did to earn his conviction?
Do I know personally? No.
Have you read the probable cause affidavit?
The only thing I remember reading is about disorderly conduct.
Okay. Do you know whether he beat a woman up?
No, I don't.
Do you know what the basis of the disorderly conduct charge was?
No.
Did you ever know?
Not that I remember.
Do you know how Mr. Cochran earned his convictions?
I do not.
But on a individual case-by-case basis, without any knowledge, you think it's okay that they're members of the department?
There again, it's a difficult question.
You know the basis of the admission from Officer Taylor, don't you?
Yes.
So here again, you and your department are treating Officer Taylor differently than anyone else, just as you did the complaints about criminal activity.
Objection, that just states the testimony, but, I'm sorry, I didn't mean to cut you off.
No, I understand. There's been a lot of testimony. If I've misstated it, it's an honest mistake, and thanks for trying to keep me honest. I think the point's been made. I'll move on. Now, Kevin Anders, is he a member of your department? Pardon? Anderson? Kevin Anderson?
He's a reserve police officer.
Okay. Do you know whether he's ever been convicted of a crime?
I believe he has a diversion.
Okay. Do you know how he earned his diversion? What he did to get in that situation?
I believe it was listed as battery.
Okay. And, but in your opinion, it's okay that he's a member of your department?
He's not technically a member of the department. He's not employed by the police department. He's an appointee. He doesn't receive money or benefits from the police department.
One other thing, I think you agreed with me that it's a conflict for you to investigate yourself. Would you also agree it's a conflict of interest for you to investigate your assistant chief or the mayor that appoints you or any member of the board of works that is responsible for your department?
Yes.
And as a result of that conflict, did you forward Officer Taylor's complaint to any law enforcement agency?
Did I? No.
And is it true that you recently received a nearly 50% pay raise?
I received a raise. I don't know the percentage.
Pretty sizable raise.
It was a nice raise.
How big was it?
Sorry?
How big was it, sir? How much was the raise?
I don't know the percentage.
I understand you don't know the percentage. Do you know how many dollars more you're getting now than you were before the raise?
Probably over 20.
Okay. That's a pretty big chunk of what your salary was beforehand.
Yes.
When was that raise finally authorized?
I don't know.
Was it this year?
I believe so, yes.
Was it after you failed, although you recognized the conflict, to send on any law enforcement authority, Officer Taylor's complaint that you, your assistant chief, and mayor that appointed you, and each of these gentlemen committed crimes?
I don't know.
Now, I appreciate you try not to let on how you feel, and I appreciate your candor in admitting you have an unfavorable opinion of Officer Taylor. But up until this incident, you had a favorable opinion of Officer Taylor, didn't you?
There were times when we got along. There were times when we had differences.
Wasn't it you that recommended Officer Taylor be appointed captain of the department?
Yes.
07?
If you would, Chief, please take a moment to review what's been marked as Exhibit 07. Is it 07 or 07? 07. Letter and number.
07 is an officer.
Thank you. And I want to know if that's your recommendation to the mayor, that Officer Taylor be.
Yes.
And I've requested already and received from Jennifer Felix a copy of Captain Taylor's personnel file. And I don't see anything derogatory in that file from you between the time, February 29, 2008, you're recommending he be appointed captain, and the time he sent this letter accusing you, your assistant chief, mayor, and several others of criminal activity on March 14, 2013. Is that the correct assessment of this file, if you know?
I wouldn't have any reason to disagree with that.
Okay. So, nothing unfavorable in his file since you recommended him for captain. He complains. He admits to criminal activity 3 years after this appointing captain letter. The day after he goes through the event, 8 days after the event, you sit down and admits that criminal activity. Nothing derogatory in his personnel file up to that point, and nothing derogatory in his personnel file up to March 14, 2013, December. Correct?
Yeah.
And you didn't ask, after Mario Todd pulled you and Captain Taylor into the back room, the Board of Works at that time to terminate Officer Taylor's employment, did you?
No.
And a week later, on April 25, 2011, when you and Assistant Chief Combs sat him down and gave him a moral reprimand, made a record of it, put it in his file, you didn't ask the Board of Works at that time to terminate his employment, did you?
No.
But at that time, you agree he admitted to being there, and by that time, he'd already received payment for that time, hadn't he?
Yes.
It's only after March 14, 2013, in his complaint that you all committed crimes, that you recommended he be terminated.
No.
When was it then, Chief, that you recommended he be terminated?
I don't believe I did.
Okay. You're recommending it tonight, aren't you?
That's not my decision.
Okay. I've been led to believe, maybe through my own foolishness, that we're here tonight because you want Captain Taylor terminated.
I feel it would be in the best interest of the police department, but he not return. I didn't say termination.
Is there anyone else in this room tonight that wants him terminated?
I don't know.
Has anyone else in this room tonight told you they want him terminated?
No.
You and the mayor haven't had this discussion?
No.
Chief Humfeld, I have no further questions. I thank you for your time and your candor.
Thank you.
Redirect, Mr. Phillips.
Just a few. When you heard from prosecutor that he was no longer going to accept information from Officer Taylor, is that before or after the April 25, 2011 meeting with Officer Taylor?
It was after.
Do you have any idea how long after?
Probably a couple of years.
So, is it your testimony that Officer Taylor would have been fine to continue to work at the department until you heard from the prosecutor that he would no longer be of value as a result of the absence of information being accepted by the prosecutor's office?
Yes.
Is battery a crime of dishonesty? Do you know?
No.
Disorderly conduct? Any of the other officers mentioned in cross-examination, Mr. Butler, been convicted or admitted to crimes of dishonesty?
No.
I have nothing further. Thank you.
Battery then is a crime of honesty, Chief? Brutal honesty, you might say. Wouldn't you agree?
Objection. Is that a real question?
Sure.
Then I'm going to object as mischaracterizing an argument.
I'll withdraw the question. Chief, I thought Mr. Dilts had asked you and you agreed that any crime, really, you don't want those folks on the department. Now I hear him to be making a distinction between crimes of dishonesty and beating up a woman. Wouldn't you think that an officer who's sworn to serve and protect, beating up one of our own citizens, maybe doesn't reflect well on the department?
I'm going to object in that it again misstates the testimony and evidence because there isn't any evidence that any woman was beat up by any officer.
Fair
There
enough.
was a conviction for disorderly conduct, which I don't believe involves battery of a woman.
Fair enough. I'll withdraw the question and rephrase. Assuming Jeremy Shepard beat a woman up in front of her 3 small children to the point she's bloodied and bruised, regardless of what a friendly prosecutor might have charged him with, wouldn't that reflect poorly on the department?
Objection. It also contains facts that are not in evidence, such as a friendly prosecutor.
Okay. And so I'll withdraw that question. Same question, but now let's assume the prosecutor's friendly and receives a probable cause affidavit from an Indiana State police officer that clearly lays out how this woman was brutally battered at the hands of Jeremy Shepard, who says, oh no, she fell down the steps, although there's 3 other witnesses, small children, that corroborate it. In fact, he was on top of her, battering her. Assume that. Wouldn't that reflect poorly on the department?
Yes.
But it's only in Officer Taylor's case that you know the basis of the criminal charges. It's not in Shepard's case. You said you don't know. You don't know if you ever knew. It's not in Cochran's case. It's not in Anderson's case. So again, tell me honestly, Chief, you're picking on Officer Taylor. You all want to hang him, and this is how you're going to do it, and your prosecutor with an unfavorable opinion of him has helped you all do it, and that's what's happening here tonight. And you've all talked about it.
There again, that's not my decision.
Thank you, officer. Nothing further.
Any questions from the board?
We're going to take a half-hour recess.
There must be nothing on TV tonight. We're all here because we got to be.
I didn't say
I'll take it down. Yes. Yeah. We heard. So. Okay. No problem.
Well, I'm just. Well, I'll go with you.
30 minutes, 30 hours. I'm here.
You don't recognize me, do you?
You two know?
Yeah.
Oh, I thought she was talking to you.
No, I know Amy. I used to coach her little kids in swimming. Alicia and Hannah?
Yeah, now I remember. I knew your face looked familiar, but I couldn't place you. Well, how are you?
74. How does it feel up there?
I'm hanging in there.
You're like a foot
Long night.
I bet it's only 50 or 60. It's just rounded up.
I am. Yeah, I actually write it with my fingers, yes. They're good. Emily, she's 13. Yeah, I know. Yeah, she's into soccer now. I think she tried swimming, but just, I guess she doesn't like because it's kind of a loner sport, you know?
Yeah.
So I don't think she likes the solitariness of it.
Mr. Dills.
Yeah, really.
Who's yelling at you?
You too.
Hi. I have no idea. I'm finished calling witnesses.
You're finished calling witnesses?
I don't know. We'll have it.
Thank you.
Have you ever gotten a raise you didn't know how much it was? I know exactly how much money I make.
I think they should have this on channel, what's the local news channel? Yeah, I think they should have this on there. The people that can't get out, they're just. Such a waste of money and effort to go on. And the only people that don't see it. Now I'm hoping the whole investigative thing. They waited so night, they went moving on.
It's not true. I didn't know that. I thought it would be.
Because that's what they said. Really? Because
It's
by then,
so
on
nice
that.
and 9/11 bringing on what you need to. I don't know if that's going to hurt. No, he don't. Not hurt.
When he's just texting me, told me she just found out there, and then he's been stolen.
Oh.
And this kid doesn't have anything anyway, and she fights tooth and nail for everything she's got. And then now this.
My daughter somebody just took my daughter's
debit card, credit card, and her credit card from where she worked at. They stole it. How? So I can have mine. And they're not paying, they're
That's one
just charging
thing,
stuff.
right, that's one thing nice that they can cancel it.
This kid. Wow.
As long as we lost it.
Yeah.
It's the people that don't lose, that don't
Yeah,
really
they'll
lost.
find out. Yeah, they'll raise $6,000 on the.
Oh, really?
Yeah.
Well, see, no,
The card company don't get your statement every day.
Well, see, I guarantee you that if anybody doesn't have a line on there,
Nobody got words on it.
yeah, I went out and tried, I
Well, that's
bought
what it said, they're
gasoline.
supposed to, no, it's supposed to be able to charge $25 unless they call the office. They, none of the places they went.
I went to get gasoline and some other stuff, and I used my card about 3 or 4 times in an area. They stopped it. I mean, they locked it up, stopped it.
That's like, oh, I don't use a credit card very much, and that same thing happened to me. I used to go, they called me, wanted to
Yeah.
verify it, but they didn't stop it.
They stopped mine.
Yeah.
Because there was about 3 or 4 of them going on at the same
Yeah.
time. And they stopped it. Of course, then they called my mobile. Once they got my message at home, they had to call my house number, and then my house number told them what my number was, and they called me. And I said, no, I'm over here fishing in the tournament. You know, I need to be able to use that card. And they said, okay. It was Seymour, Indiana.
Yeah.
Oh, I'm sorry, not Seymour, but Bloomington.
What goes around comes around, the changes watch me, that's what I said. Make sure you tell them. Break, like, you know, over with. 30 minutes, I mean, at least 3 minutes out the hallway, are they all good to somebody? I'll see more for you guys. At least 3 minutes out the yard.
I know you are. Right, that's good. He's not home.
James, they didn't have any cards, I heard him say. I said, oh, you guys can put him on your lights, he said, no, we can't put him in. I said, oh, you're the witness. One man says, oh, I live 5 minutes from here, can I go home and then call him? I'll call, yeah. Then he looks right over my arms. Where's it go from here, Doug? Then we just hear all of this and then they all get their nasty heads together and
So, they're still gonna decide whether you stay or go. Then why are we wasting all this time? Because we already know what they're going to decide.
feel just like they said, none of them up there have any prejudice against.
Yeah, right. And they
Well,
would never,
You know, sometimes,
and they've never
when
discussed
everything
it.
has been brought out like it's been brought out.
That's very true.
Sometimes,
They're gonna have to determine.
even they would have to. I mean, if I was a innocent bystander, which I basically am, in this, if I heard what I heard tonight,
How can they?
yeah. On nothing other than they have police and big people. that
Well, they wanted to cover Jerry
convicted.
Shepherd's ass, didn't they?
But they, yeah, I mean, people that convicted for crime, working for that, or that's enough right there.
Yeah, in fact,
That's what I hear.
That's more than a felon.
That's all you would have had to, that's all.
In battery,
I thought you had
that's
a
not
clean
a-
record to be.
It's a misdemeanor. That is a misdemeanor.
I thought you had to have a clean record of it.
You've got officers just having DUIs and things like that.
Yeah, but,
You know, we're only human.
I know, true, exactly. Nobody's perfect, is the way I feel about it. Well, they said all these people, when they went to ball games and things, it's no different than what you did. So what's the difference? I can't believe that somebody just really got a hard on for you. And that's what it comes down to. But people got a lot of it for them too.
What the problem with is the people that do, the ones that started all this shit, not me. You know?
between the lines. Doesn't know anything, that's what they all been told, I don't know anything. I can't remember.
Anybody want to bet me $1 who he's over at the Brickyard having a cocktail?
I think we should all be over there. I'm Darlene Griffiths. I was the
She's my hayride, she's my hayride.
25 years. Oh, that's where I
Me
recognize you
and
from.
her and Amber went on a hayride together. And with a pumpkin match. What got us a pumpkin?
We've got grandkids. You know what, I appreciate that.
You know what we're doing? I asked Doug earlier today, I said, well, you're very good at your execution. It doesn't matter what we do. We know what we're going to do. We know why we're going to do it.
And we'll come back, right?
Yeah.
Not for these jokers, though, but if he'll go somewhere else.
Probably get a special judge. It's not low, but won't touch it either. So,
It's been here to
how do you think it's going?
I think it might, as far as Doug, it's Doug's favor. Those people do it. You know, nobody uses it.
I think just the
They've already
chief,
got their
just the chief
mindset.
of police was great. Oh, yeah.
Yeah.
That's what I.
He doesn't know anything.
I don't know if you saw me smiling,
But
but
he knows Chambers.
No, and you don't run the clock.
I don't know if you saw me smiling or not, but I was getting a pretty good kick out of it.
Oh,
I've never ever worked a job I didn't know, so.
yeah. I told Doug when I get thrown out that you're supposed to tell him his stand. Doug worked for me years ago. We've been friends with him and his family for years.
I've only known, I
He
personally,
goes to church where we go to church. He's a super good man.
I've known that for a long, long time, don't get me wrong. Personally, I've only known him for, since he started politics together. I don't know that.
Long time.
And I was the one that went over and paid for the cards that said, when all these guys started politics together, keep that man up there as a team. And I went over and bought the cards.
Which man?
Him.
No, you said up there.
Mike.
Oh,
And
for
the guy
Mike,
sits right,
okay.
no, the guy sits right up there.
Behind the
He was
podium?
one of them.
Behind the podium?
Yes, yeah. He was one of them. His name was on that card. And I told Doug, and I told Mike, I said, I'll pay for his cards. I said, this is part of your election card or whatever. I said, but I'm not doing his because I don't know if you was there that day or if I did in front of Mike. I said, no, I'm not doing his. It's for you guys, I ain't for the rest of it.
I think he's taking Jared Culver over there.
Okay. We can do the trash.
Yeah, I think it's time for the hammer to come down. I just wish it would. Wish the TV stations would have stayed with that. Did they interview any, did they interview?
They had to do work enough to get rid of stuff.
Now you're done. Used to be in jail. Used to be in jail. I haven't seen her. I've seen Jamie since.
I can find it for you.
They are down across the street.
I think I know where she's from.
I thought Dad lived down here still.
He does, so where?
I live down here.
I live over in Center.
When you do?
Oh,
I see you were
a couple
talking
years
about-
ago.
She does soccer? No,
I might have been from Maine and my nephew went by, not only, I've never, I only drove by them.
The Monday night, somebody put a front.
I'm at the soccer field yesterday, and I took my daughter to cross country to school too. Cause we got 4 kids, I'm always trying to do something.
Yeah.
But then not the football field though.
And then I couldn't figure out you.
Yeah. No, my son plays, but he plays varsity JV, but it was not yesterday. But my nephew was
But
playing.
I live in, at 7th.
Yeah, they said that. No, I don't.
I didn't think he did.
Yeah, I was over there right when the game was going to start picking up my daughter at JV, at that middle school, driving by the football field.
That's where I saw it. Yeah. That's pretty good, pretty good.
Sometimes I go from cross country to soccer to different soccer and just ball.
That's the way our refrigerators get. You know, it's all one big long list now of all the schedules.
Yeah, that's what ours.
And now we got band on top.
Yeah, we got 6 or 7 schedules on our fridge.
Of all the kids that I would have thought, never be interested in that. Will loves it.
Yeah, you know, he was playing. He's playing playing on Marshall High School.
Yeah.
He's only 7th grade. Two of them. They're great big. Really?
Yeah. No, one kid that I guess he's the main captain, he played for 2, but he was there at the last meeting. I don't know if you were here or not.
No, I picked up.
Where's your son? Junior varsity.
11.
I picked up, I didn't see those.
Junior?
Yeah. Logan Scudder.
What is it?
Logan Scudder.
I think it's good about as long as
Yeah.
it's in the afternoon. Really, we just never see him playing.
No, I don't know that, but I know he is. I didn't look.
Since grade, the last grade period. He takes place till the first grade period.
So that he's got about what, four more weeks or so.
He don't know, he's paid for that.
Yeah, he's probably got 4 more weeks.
He was playing junior, freshman, junior varsity last year.
Yeah.
Football and basketball.
Yeah.
Yeah, Josh, and then Josh got started in 7th again.
Yeah. Yeah.
How do you expect this child to do this and carry on?
Yeah.
And that was way game, most of the time.
Yeah. I mean, we have 4 kids everywhere from Logan to 17, and we have a 2-year-old, so we have diapers to the driver's license, and I mean, even the kindergartners. I mean, he has soccer till he has 7, 7 nights. I got hurt to get him home to do his kindergarten homework, so it's really hard for the older kids. Middle school's the worst, though, I'm thinking about homework and stuff, but
We had 5 grandsons from sophomore down to,
yeah.
or 6, we were at 5 of them were in football.
Yeah.
And it was one week we watched 16 people.
Yeah. Well, we're like on a weekly basis with Logan. We have 2 football games, 2 soccer practices, 4 cross country practices, and cross country practices every other week. Yeah.
What's your nephew for? What's your son for?
Line, inside line, or outside lines, and if somebody gets hurt, usually inside, but
I followed that first year team before Trevor, it was awful. They lost everything.
yeah.
Me and Dave was sitting out in Carnes there. Only 2 people there on Lawrenceburg side.
Yeah.
40 to nothing. Raining as hard as it could rain.
They did good now.
We're sitting with our umbrellas, just me and him.
Yeah. Yeah, like the high school won 63 to 13, and then the JV on Monday won, I think, 36 to nothing.
That was a great game. That poor Trevor has played that bad.
Yeah.
7th grade, 8th grade, freshman, lost everything, and then that coach was so hard on him.
Yeah, they're all scared of the coaches.
And then on the way home, they had nobody to practice.
Yeah.
When we were at the Connersville game, we had a couple of Subways, and we got a deal on cookies. We had like 5 boxes of cookies.
Yeah.
Give Trevor 2 Subways.
Yeah.
Boxes of cookies, he could pass them around.
Yeah.
Quietly.
Yeah. Yeah, the kids are all scared of the
So
coaches.
we were looking so forward this year, you know. And then
I know that my middle schooler, she just got her progress report, which should mean it's the middle of the 9 weeks.
it's like
This
October.
week, so it should be about 4 weeks or so.
We'll only get to 3 more.
Yeah.
But he's allowed to practice, get dressed.
Yeah. What number is he?
18.
I'm
He's a wide receiver.
61.
We didn't know, his dad didn't know, none of us knew, all the parents knew, but we didn't know
I got targeted.
until homecoming.
Yeah.
Oh, it did.
Yeah, one of Logan's friends are a wide receiver, that Jordan Tossman.
Yeah.
That's not Logan's friend.
Was he sick?
Hey, Jordan?
Tipsy recently sick?
Not that I know of. I mean, we went on vacation, was in August last month, and he went down on vacation with us for a week, and not that I know of.
Well, I think this was a way that Trevor just...
You want to go work with him on concrete?
I saw the original Facebook, and he was sitting in the hallway.
Yeah.
Josh, kids don't do this.
I wouldn't.
Yeah.
You have security cameras at your hotel?
I wouldn't want to be.
Yeah, I mean, I feel like a lot of them are. I mean, Logan don't get home
Used to
until
be.
something at night
I think.
from football, then he's got homework, and then they got, sometimes they got weightlifting at 6 something in the morning. Yeah, it's crazy.
It's
Yeah.
so hard to do because people.
It's, I mean, it's too much. and
It's
it-
too much.
Yeah,
They
it's
shouldn't
too, I've
allow
always
the
thought it's too
pressure.
much.
Yeah, but I'll tell you what.
Yeah, or even older kids, I mean, it's too much homework.
It is.
I mean, I know they want to keep up with the other schools, but at some point, they gotta go online.
Trevor, he was just exhausted. And then Josh, our son, went to
Yeah.
PTSD.
Yeah.
He takes it out, like what he did, he drives hard. You know, he's
Yeah.
not going home.
Yeah.
He does it all in sports and stuff like that. And he drives hard.
Yeah.
And I told him, I said, it's just too much.
Yeah. I'm good. Yeah, I always feel like it's too much, especially football.
Well, he loves it, but, you know, they're not going to play there.
Yeah.
Tickets get broke. Bills get playing this year, so I get
Yeah. Yeah, that's crazy. The only good, I mean, the easiest as far as practice getting, I feel like is soccer, because at, middle school and younger, and going like once or twice a week. I don't know how it is high school. Does it?
I don't think it lasts too long.
Yeah, and they have to go back through.
Well, I haven't. Donnie, where'd you get that water from?
I got it upstairs.
Upstairs?
Yeah. Run up first.
Yeah.
I've been zipping on this, I mixed this up. Supposed to be lemonade.
I seen it, a different color.
Rusty's growing up.
What time did they go on reset?
I didn't write it down.
She's so tiny. Isn't she? But she's a cutie pie.
They pack her around.
Did she go back to Manchester? She ain't
Scholars, little scholars. She's out there by you.
Yeah.
AJ loved that.
All right. Excuse me. How about you?
Just put your, just put in a cold piece. I gotta work tomorrow.
Must have a boring night. I think it's me too.
It's not very often that I go. She don't have.
Yep, right at it. 4 hours, 5 minutes.
They go in the same hospital? No, I didn't even know.
All right, anybody in the audience got any Snicker bars?
I got some Nutter Butter candy bars.
The lifesaver.
Truck.
You got a lifesaver, you want a lifesaver? You have to have chocolate.
Chocolate, that's good.
I got 2 Gatorades out there too.
My purse, I don't have anything. Gone, that didn't work.
Did you ever pick Logan up last night, Mike? He was at the football game.
I called his mother, and she said he was going with her.
Oh, okay. Yeah.
Well, then he called, hollered at me because I left. I couldn't believe you there. I said, I called your mom. She
About 6 o'clock.
Which tractor?
Thanks.
Oh, he has. Oh, what he did. That's what everybody. So we gives you that idea. He says, I saw it going by your house. I saw her. Jake says, you ain't gonna believe this when Brett's on the tractor. I said, no. I said, for cash money? He said, yes. He said, he got this deal. I looked up the details and I see
This is the actual original. But I don't know if that should be. Right.
Well, yeah. It's like half the party cleared out.
I mean,
That's right there by,
Started today. Starts down.
No mo.
I'll be up there. We was
What we provided you with.
surprise yourself, huh?
That's what these.
Where'd you get all those touchdowns?
I don't have the records, was Jackie supposed to bring? That's what So, yeah, I mean, I got a line, but I
Roar
think
that
what I
back.
said, so my original objection was.
This year.
Oh, yeah, you. Other people. Yeah.
I heard about it.
These are officially adopted. I don't know that they are.
See whether they were officially adopted is, in my mind, irrelevant. That's the policies of the operating under the practice.
That's hard on killing.
The selling, yeah. I give him a lot of credit.
No, I should have copies at the office.
That's okay.
Because I have a copy that I brought that don't have all the stuff.
It doesn't have this page in it.
I'm seeing that.
I know, you're not campaigning or nothing.
I don't get out of the office much.
Hello. Yes. Sure.
I'm up there all the time.
What works for you?
Go ahead. Yeah, I'll let you help.
Actually, I just scheduled something about a half hour ago for them. Somebody coming down from Ohio. What's your other availabilities?
On schedule, let's go.
Okay. Let me see how it goes for Friday. If I can do it, I'll call you. If not, what works, I think.
Guess we'll see how that works out.
Nobody here to take
Actually got some pretty.
what's up against people.
I think one else we can do it.
It's hard to get them to come down at nighttime.
It's holiday on Monday.
Yeah, I'll make it.
Pulling away, leaving my little girl there.
Tuesday? Okay.
All went out for the 50.
That works for me. I'm pretty wide open. What time you want to do it?
We'll see. We've been working. They gotta have so much traffic.
All right, thank you.
Make
I'll
it
see you
go.
then.
Yeah. The road traffic. That's the reason, red light is but I'm a traffic announcer. Did they do a traffic count? Oh, there's 63,000 every day, but you get this time now, that's what they look at.
From Columbus.
Good thing we're going to put it on? Good. You keeping all pat? Good. Yeah. Third and yeah, that's everybody though. You know, everybody goes through that. I've been 35, 34.
me out.
I know, it does. Then you look around, where did time go? Right? Yeah, hey, we gotta get over it. How you doing?
All right. We can remember, it's been easier, wouldn't it?
You messed up.
Okay, so
Still want that CV? What's the scary?
That's my That's just another digital.
So this could also be the joint. That train's heavy on.
That's fine.
This can be entered as
Giving up the word.
I didn't have a free will touch.
Giving that vacancy, give you a verse what I.
Is this our copy? Oh, did you copy the signature page?
Like I said, it should have a free will touch.
How'd you punch it? It's not punched either. I see it. Yeah, can I have this and let me see what I want to do?
Your Honor.
That's right. Public hearing back in session.
Chief rests.
Okay. Mr. Butler, you may proceed. You're direct.
I called Jackie Stutz, and I've indicated to the board's lawyer, as well as Mr. Dills, that I haven't seen her about the premises today, although I know she was properly served with a subpoena to appear. That surprises me from Jackie. She's been around a long time, knows what the rules are. The statute allows you all to force her to be here and testify. It also allows a local court to compel compel compliance with the subpoena by attachment, commitment, or other punishment. I, of course, don't want to do anything like that. I don't know why she's not here, but she was subpoenaed along with a number of records, and we need those in order to proceed. So, any thoughts or ideas? Absent any, I'll be asking that we continue this matter until such time as she can be made, or voluntarily, which I think she will, comply with the subpoena. I know she was here last time when she was subpoenaed.
What records from this first subpoena did you receive?
I received a number of them, some pay records. I received the SOPs or SOGs from the Lawrenceburg Police Department, some employment contracts, some ordinances, those kinds of things, and considerable pay records. But there are considerable records that she hasn't yet provided as well.
Can you let me know what those are, please?
This is the old subpoena that was provided, although she provided an updated correct date and time. The record request was the same. There's what she was subpoenaed for today. There's what she provided.
What's on the flash drive, do you know?
I believe that's the fire department standard operating guidelines.
Okay.
And I'm guessing that from the label that she put on it. Makes sense.
So what are you alleging that she didn't provide, I guess, Mr. Butler?
Quite a number of records, including but not limited to records of this board establishing rules and guidelines that control the police department. Indiana Code 36-8-3-2, paren D, provides that the safety board may adopt rules for the government and discipline of the police and fire departments and adopt general and special orders to the police and fire departments through the chiefs of the departments. We've asked her for that.
That's not contained in here, is that correct?
It is not. And I think there are a number of other records not in there as well. And again, don't misinterpret anything I'm saying here. I'm not trying to be critical of Jackie. Those are a lot of records to provide. She was here last time, and I'm concerned that she's not here this time. I'm not asking that she be punished or held in contempt, but certainly we've got a right to call witnesses. She was properly subpoenaed, and we need her to proceed.
Do you have other witnesses?
I do, but the order of proof we need to proceed with is starting with Jackie. She's got records that other witnesses will rely on.
As with what? I mean, what particular record are you talking about?
Well, the one I just identified for one. At issue in this case are the standard operating procedures, significant issue.
Standard operating procedures of the police department?
Yes.
We provided copies of the standard operating procedures before we started tonight.
I understand that you think you did that. I'm not sure those are what they purport to be. And those records that I've asked for will help me determine whether they are what they purport to be.
Mr. Dole?
My perspective is that, one, I don't know why the witness isn't here. But second, from what I've heard, I haven't heard anything yet that relates to any alleged misconduct on the part of Officer Taylor or any issue related to the chief's decision to request Officer Taylor's termination. What we have provided in part...
The chief didn't request Officer Taylor's termination. He made that very, very clear in his testimony.
request that Officer Taylor not return as an officer. I still haven't heard anything in the records relative to those issues, which are the only matter before this board, is whether it's appropriate to have Officer Taylor's employment terminated so that he does not return to the Lawrenceburg Police Department. Whether the board adopted any additional procedures beyond the SOPs that have been provided is somewhat irrelevant if these are the operating procedures that the department has been operating under as a custom policy and practice. And I think it's fair to represent from Chief Hunnefeld's point that that's exactly what has happened, which is why we offered C2 as an exhibit. So failing that, if the only other records to be provided relate to the alleged criminal misconduct of anyone else, including the board or the chief or anyone else, I think they're not appropriate or germane to these proceedings, and therefore we should be able to proceed just fine without her or the records.
Just want to point out, Your Honor and the board, I'm taken aback by Mr. Dilt's stance. When you sent me the notice that we're going down this road, you said, here's some SOPs. There's a statute that provides how SOPs are being adopted. I've cited it to you. I've asked Ms. Stutz to bring proof that that statute's been complied with, and those are indeed the SOPs. But yet Mr. Dilt says, well, it's not relevant. There's nothing in there that's relevant. I've also asked that she bring proof of any rules that you all adopted for the government and discipline of police and fire departments. Rules you all adopted for the government and discipline of Officer Taylor. And I've also asked that she bring proof of any general and special orders that you all adopted. And Mr. Diltz, although he has no idea what they says or what they say, says they're not relevant. I wish I was so assured that what I don't know is not relevant. The fact of the matter is, you may have adopted rules regarding discipline, which is what we're here about. And to hear Mr. Dilt say, we haven't requested anything relevant, just takes me aback. I am shocked and amazed that although this statute says we got the right to call witnesses, if they're not here, we got a right to petition the court and you all to make them be here, and you're all seriously listening or considering taking that right away from Officer Taylor and not letting him call witnesses properly subpoenaed for evidence that is relevant?
As far as Ms. Stutz's presence here, besides the records, okay, what if any information would you be able to glean from her?
I just need the records.
You just need the records. We provided a copy of the SOPs that Gene Hunnefeld has been working under. They were signed by Mayor Cunningham and the 2 Board of Works members and Chief Hunnefeld. We have the original signature in front of Mr. Hunnefeld now. So, I mean, those are the rules for government and discipline of police adopted by the Board of Works and Safety.
I understand that's your position. It was also the city's position.
There's also a special order, which is at the beginning of those SOPs, which looks like it was done at a later date, 4/29/05, I believe.
I appreciate you believe these are the properly authorized or passed SOPs. That still doesn't address, and I don't necessarily agree with that. I think there's a statutory procedure for that to happen. and I've asked for documentation to determine whether that's happened or not, because one of the things you're all seeking to do is terminate his employment based on those SOPs. You've also got the right to pass rules about discipline. I've asked for those. And look, you're either going to let Officer Taylor have his right at this hearing to call witnesses, and he's properly subpoenaed them, or you're going to take away his right and barrel through this thing. I've made my, and so I suggest, so that we can present our case, that we adjourn and find out why Jackie's not here and get her here. Whether it be today, tonight, tomorrow, however you want to do it, but I don't recommend that you all take away Officer Taylor's right to call witnesses and have records produced. Again, the statute, and I'll cite it to you, 36-8-3-3D contemplates this very, very thing.
When was this subpoena served, sir?
Yesterday.
Yesterday?
Yes.
Is that proper?
Hmm?
Is that proper?
As far as I know.
Sure. Mr. Brenner would like to
That
ask.
question? Just curious, but, you know, if I was to get subpoenaed to court and it was tomorrow, would I be delivered a subpoena today? Just curious, or would it be
You could
2
be.
weeks from now?
You could
Or
be.
2 weeks earlier, or whatnot?
My understanding is you can be subpoenaed anytime. If you've got a problem complying with that subpoena, I think there's two things you can do. One is you can get on the phone to the folks that subpoenaed you and say, hey, you didn't give me enough time, I've already got plans, I got to work, I got to take my kid to the doctor, whatever it is, stuff happens, life. If that person is unreasonable, then you can ask the court or this board to grant you relief from that subpoena, which says you have to be here. But and it happens a lot of times. You just can't get your subpoenas out months early. I think I got into town last week. I've been gone nearly 3 weeks. And I had a lot to do, and I didn't get them out as soon as I'd like to. I found out a day or two after I got here that there was a new hearing date, which is fine. Not complaining about that or nothing about that was inappropriate. I was gone out of the office, not checking emails. So she got it more than 24 hours in advance. Didn't indicate when it was served that there was any problem being here. Had I got a call about it, I'd have been happy to figure out how we otherwise skin that cat. Look.
Mr. Dilts, do you have any response to this?
Well, I think the fact that it was only served yesterday suggests perhaps why she isn't here, but I don't know that. I guess my point is, with respect to calling of witnesses and the production of documents, yes, there is a right to do that. There is not an unfettered right to do that. As in any proceeding, you're governed by what's relevant. Why are we here? And in my estimation, determining whether the SOPs were properly signed, I mean, we're not dealing with a DNA chain of custody problem right now. The board is the board. You guys know whether or not you properly authorized the SOPs. They're a matter of public record, and quite frankly, if that was going to be Mr. Taylor, or excuse me, Officer Taylor's defense, then that subpoena could have been served months ago, back in March or April, or whenever the first subpoena was served. What I still haven't heard isn't these records are important and relevant because I believe they're going to show fill in blank here. What it is Mr. Butler is attempting to determine whether or not the SOPs that have been operated under since 2005 are, in his estimation, lawful. And again, I think that's a matter that could have been investigated some months ago, probably as a matter of public record, since you guys can't take any action without a public record, and remain not germane to the proceedings at hand as it relates to Officer Taylor, since we know from Chief Hunnefeld that these are the operating procedures that the department has been operating under since about 2005. They were revised after the Jeremy Shepard incident. I think that was his testimony in that. So whether or not we're dealing with something that Officer Taylor thinks was appropriately ratified, you, the board, know whether you ratified it or not. That's within your knowledge already, because you're the board. So if that's the situation, then I don't think that the witness's testimony or the records are going to add anything of substance. And then, again, to the extent that there are documents reflective of any alleged criminal activity on behalf of any of you, those aren't germane to these proceedings either, for the reasons I've already mentioned way back when. And so while I'm always, I don't know, excited when I get to shock the other attorney, I didn't find that this is all that shocking, given that this is within your particularized knowledge, and there doesn't seem to be or purport to be any allegation or evidence that there's anything improper about what's already been turned over.
I agree with Mr. Dilts that we don't have an unfettered right to subpoena witnesses, but we didn't go off on a wild goose chase, subpoena some crazy witness so we could delay this darn thing. We subpoenaed the keeper of your records. We gave her the subpoena, asked for those documents back in early July, so it's been more than a month and a half. She provided me some of the documents back in July when we convened, got no other documents from her. Most of that time I've been out of town anyway. And let me fill in the blank. I don't think that to show that these are not the operating procedures, because I believe that, and I agree, we may just disagree on this. The fact that you want to say these are standard operating procedures when I believe there's a statutory procedure for passing standard operating procedures, that's our difference. I think this board also doesn't know, because the very ones you gave me purport to be passed by the board of a previous administration. Mayor Cunningham, Charles McNemery, and Steve Lucier, none of whom are on this board. And maybe this board knows whether it was properly done or not, but I think we certainly, in defense, when you're seeking to terminate this man's employment, in part at least based on those SOPs, have a right to prove these ain't the SOPs at all. And I've asked for the records. She's not here. Not our fault. No complaint that she couldn't be here, that it was a problem. Had there been, I'd have called you all, we'd have figured it out. But so here we are.
Also, we point out to the board that the C2, Exhibit C2, that was presented by the chief, there is an acknowledgement by Mr. Taylor that he received a copy of the new SOPs, the ones we're talking about that chief brought today, and that that he acknowledged and understood those SOPs. So we would ask for, at this point, for the board to decide how they would like to proceed. There's been a motion to recess this until Jackie can be here. As Mr. Dilts stated, I feel we did provide a copy of the SOPs as
Leslie,
the chief.
To your point, if I could, you said that there was a signed acknowledgement on that C2. If you recall at the beginning when that was put in, I objected to that exhibit to the extent it did anything other than showed what Mr. Taylor received. I objected on the grounds that I don't believe those are necessarily the SOPs.
Okay, but there's still an acknowledgement by your client that he received the SOPs from 2005.
Again, I objected to the introduction of that to the extent it does anything other than show what he acknowledged he received. That's not an acknowledgement that those are the SOPs properly.
I was just pointing out there's an acknowledgement that's in the record.
I get that. I wanted to make sure you didn't miss that point.
Maybe I'm missing something, but client's here. Can you testify about whether these are the SOPs you got?
Again, is nobody hearing me, with all due respect?
I
believe there is a statutory procedure for the passing of SOPs. I've read it. I've cited the statute. My client doesn't know whether that was followed. I doubt anybody here can tell me whether that was followed. We've asked for records to determine that.
That wasn't my question. question was. And maybe I misunderstood your objection, because the way I heard your objection, and I've had problems with my ears, is that it was merely an acknowledgement of what he received, but not necessarily that these are what he received. And if that's not your objection, then I'm sorry, I didn't hear you.
No, and maybe I wasn't articulate enough. Maybe I didn't state my objection well. No question he signed that, and that's what he received. No question that's just a portion of what he received, and you pointed that out. What we're contending all along, and what we intend to prove with our witness and her exhibits, is that these are not properly statutorily passed, approved, and therefore not SOPs under which you can terminate this man's employment. We think he's only bound by them if they're proper. We think under those circumstances we certainly have an opportunity in our defense to try to prove whether they're proper or not. And we think the records will show, frankly the lack of records will show, that those are not the SOPs.
Can I please have a copy of you?
Yeah. And while you're looking at that, let me point this out too.
Are there other SOPs?
Pardon?
Are there other SOPs or just no SOPs?
I don't know. And we're not just talking about the SOPs too. Let's not miss the focus of what I'm saying. The board can also adopt rules for discipline. I've asked for those. I don't know how we can say those are not relevant here. Now, I don't know what they say. They might grant this man salvation. They might hang this man. I don't know. And as you pointed out earlier, we don't get an opportunity to do discovery in these cases. And for the board's edification, it doesn't matter what documents you all sign. You can't take official action without a properly noticed public meeting. So Leslie can show you that the mayor, Mick, and Steve signed those, but that doesn't mean there was a properly noticed meeting and the board took official action to adopt them. Again, I've requested those records.
I don't see a problem. Mr. Bruner would like to ask Chief Hunenfeld a question.
Mr. Hunenfeld, the SOPs that were given to us, were these SOPs kept at the police department? The book, the SOPs, were they kept at your police department? Okay, but they were kept at your police department? And are those the SOPs that the police department has been operating under since 2005?
Yes.
Thank you.
Mr. Bruner, if I can, I think I understand where you're going with that question, and not to pick on a particular point, but the fact that people do things is not proof that it's lawful. We all know now that a bunch of 5-year contracts were entered into by the city of Lawrenceburg, and we've since learned that those aren't lawful. So I'd hate to be at a hearing where you ask that same line of questioning about the 5-year contract, and we're stuck with the fact that, well, it's a contract, because the fact of the matter is the law matters. And the fact that people operate a certain way, pursuant to a certain document, doesn't mean they lawfully may. And it's a pretty important issue to Captain Taylor, whether these SOPs, as well as any other discipline rules and other things that we've asked Ms. Stutz for.
Mr. Butler, you subpoenaed her in July for some records, you said?
Yeah.
And you received much of them.
I think you were...
Here you're saying it's so important, but you give her a 24-hour notice, and I'm sure you're aware of her load she has over there and how hard.
She's known since July. These aren't new records.
They were on that list, the July list.
They were requested in July too.
Everything you're asking?
Yeah. Everything. There was no changes. I asked for exactly the same things I asked for in July. She kindly brought some of them and provided them at the last meeting, and I've got those, and I've shared those with your attorney. But she doesn't have the others. And guys, look, I know this has been a long time coming. I know we all want to get past it. But I'd hope that you'd want to get past it in accordance with the law. We got a right to call witnesses. We subpoenaed a witness. She didn't show up. Now, if that happens down there at the court, that person could end up in jail unless they got a darn good excuse why they're not here. I don't want to do that to Jackie.
So the recess was requested, Mr. Butler. The board needs to make a decision. We could go back and forth for all night. So we need to know how the board wants to proceed. You want to proceed with the records that were presented to Mr. Taylor and the records that were produced by Ms. Stutz. He's already indicated that Ms. Stutz was not needed here for any live testimony. And as far as the rules of evidence, as stated in the pre-hearing entry, the rules of evidence are not necessarily enforced as much in an administrative hearing, meaning normally if she were in court, she would definitely have to be there in order for these records to be certified by the person that, is the keeper of those records or one that can authenticate those records. I think the rules of evidence in this type of administrative hearing are lax in that respect. Some hearsay is even allowed. So I will leave it up to the board and how they would like to proceed.
Donnie, what's your pleasure? What's your pleasure, Donnie?
I'd say we go ahead with the hearings, the records there, what he asked for. Jackie.
Bill?
I say we move forward. We've been operating on it since '05.
Aaron?
Mr. Dilts, is it your recommendation to move forward?
Yes.
Okay. Yes.
2005, they redid the SOPs, and I think
Board voted to move forward.
Let me call your next witness, Mr. Butler.
Well, before I do that, I'd like to make a motion of the board pursuant to Indiana Code 36-8-3-3 paren D to order your clerk to immediately present to the circuit court of the county a written report of Jackie Stutz' refusal to appear in Pride records. The law also says, under those circumstances, the court shall hear all questions relating to the refusal to testify or produce evidence, and shall also hear any new evidence not included in the clerk's report. If the court finds that the testimony or evidence sought should be given or produced, it shall order the person to testify or produce the evidence, or both. And Leslie, that statutory section I referred you to says if a witness refuses to testify or to produce books or papers in the witness's possession or under the witness's control, Indiana Code 36-4-6-21 controls to the extent applicable, and that's the statute I've made the motion under, and I was reading from the statute. And again, that's to compel or to order your clerk to immediately present to the circuit court a written report of her refusal to testify, so that we can have her here to testify pursuant to the subpoena.
Do you have quorum with Ms. Jenna?
The result of this is that Jackie is going to end up hauled into court tonight or tomorrow. Then I'll for whatever this is worth from our perspective, withdraw my recommendation that we go and proceed without her. And because the only other alternative I can possibly see is if the board were to find that her testimony and the documents were in no way relevant to these proceedings. And I think to the extent that there are or potentially are regulations relative to the discipline of officers, I don't think that that's a viable option. So,
Would you please give me the statute again?
Yes, and I'm not asking that Jackie be hauled into court, but the statute says we got to follow this procedure. And
36A.
The procedure is for her to petition the court, and then she's going to have to answer to the court. But again, I want to work it out amicably. It's the statute we're moving under in this case. It's 36-8-3-3(d). And then it references, Mrs. Votaw, 36-4-6-21.
That's not the right referral. 36-8-3-3 is the organization of the safety board.
I'm sorry, -4. 36-8-3-4D.
Thank you.
4 is the one we're under. My mistake.
Yeah, that's right.
And then, like I said, it references
So it
that
confused
30.
me. Hold on.
I'm sorry.
Okay. If a witness refuses to testify, to produce papers, or to produce books or papers in the witness's possession or under the witness's control, this 36-4-6-21 controls.
the other alternative, if I may, is to proceed with all of the other witnesses and simply defer the current witnesses' testimony and production of documents. Insofar as nobody here knows what the documents say or don't say, it's impossible for any future testimony to somehow be predicated on the documents that I think we've all conceded we don't know what they say. So I think that would be another option to at least get through a majority of this tonight, even if we eventually have to reconvene for the purposes of having documents produced by Jackie.
The only problem with that, Mr. Dills, is that I've asked for, and again, not on a witch hunt or just throwing stuff out there to be difficult, but I've asked that she produce 48 different items. And I think your proposal is referencing just a few. And if we want to go through all 48, I don't see us wanting to do that.
I've never seen the subpoena. I have no idea what we're asking.
I understand that. So, and I was provided a lot of records, some of which I don't want to use at this point. But here's a lot of them. And there's still a lot on this list of 48 items.
I do want to stop you for a second. It does say, if a person refuses to testify or produce evidence of an investigation conducted under this section, the legislative body, who would be council, may order its clerk to immediately present to the circuit court of the county a written report of the facts relating to
I agree that's what it says, but I think what they're saying in that 4D is use that procedure. I don't think it refers to that other statute, and you're right, I think it's for a council investigation, but I think they're telling us to follow that same procedure.
But that still would be the council that would direct the clerk.
Well, it seems to me, and I suspect, I mean, I'm flying blind here just like you are. I think what the legislature is trying to tell us is this board needs to use that procedure to get those witnesses at its hearing.
Board's call.
I don't know, Leslie, why they would refer us to 36-4-6-21 to solve.
4621, just for the information of the board, is the general legislative body's powers to investigate. And under that, Part C, which doesn't rely on any other part. If a person refuses to testify or produce evidence at an investigation conducted under this section, the legislative body may order its clerk to immediately present to the Circuit Court of the county a written report of the facts relating to the refusal, which she would be ordered to report findings of the facts relating to her own refusal, or as it may be, why she's not here. I'm not aware of any either. The court shall hear all questions relating to the refusal to testify or produce evidence, and shall also hear any new evidence not included in the clerk's report. If the court finds the testimony or evidence sought should be given or produced, it shall order the person to testify or produce the evidence, or both.
And again, I'm not trying to hold Jackie in front of the judge, but
If you want, this is D under that statute, and then if you just hit right there, it'll go up.
Mr. Dills, do you have that section 4 of the other statute?
I believe I do. If I hit the back button for that,
Actually, if you just hit the blue part in section D, it'll go straight to that.
Your office is way more high-tech than my office. You want that?
Is the other section attached?
Pardon?
36.4, is that attached?
Was 4 attached to it?
36.4. I guess my only thought on the matter is that the legislative body may order its clerk to present.
How does the board want to proceed?
Tommy?
Looks like we're going to have Jackie here. As soon as possible.
I do know, the only thing I can say, I'm not sure why she's not here. I'm not sure that her deputy clerk knows why she's not here. Her deputy clerk was instructed to be here, and I did speak with her about having someone here, because I do believe the clerk treasurer is part of the Board of Works and a public hearing. So we did make sure Suzanne is here for that purpose. As far as this issue, for one thing, I do know that the judge of the circuit court, and I'm not sure whether they are going to bring a pro tem in or a senior judge could hear it, but that judge is out for the next 10 days. And I think Mr. Butler was aware of that. We spoke with Judge Humphrey on Monday
Listen,
concerning.
I say one thing. I do know that, and again, my goal isn't to haul Jackie in front of court. I think it's unusual that she's not here. She was here last time.
I understand your position, Mr. Butler.
And so then I just had to make the motion to preserve the record. But if it does get continued, I expect that Jackie, we'd eventually be able to contact her and she'd voluntarily appear for our hearing. And my schedule's wide open. If we got to schedule it for tomorrow or the next day or whatever the heck we got to do, this is not a delay tactic. We've subpoenaed her and she's not here. I've got no vacation scheduled the rest of the year, by the way, and very little else on my calendar.
So, at any rate, it does have procedure for when someone is not here. I don't know whether or not, it does say if a witness refuses to testify or to produce books or papers in the witness's possession. I'm not sure, I mean, the board doesn't have that information, and whether or not she refused. So I would leave it up to the board. I know the board wants to go forward and hear this matter. As far as him relying on anything that she should have produced, the only records that I can see that she didn't produce were the minutes of the meeting under which the SOPs from 2005 were adopted. Am I correct in that, Mr. Butler? Did you see any other pertinent records?
There's a bunch on here. I've asked for the Board of Works written notice to Officer Doug Taylor, the hearing pursuant to Indiana Code 36-8-3-4-C.
And that's what you've entered as your exhibit today, correct?
I hope that's all it is.
That's what you received as part of Mr. Taylor, isn't that correct?
There's no question I received that.
Okay, well then.
But I don't know what else is out there. I've also asked for all rules for government and discipline of police adopted by the Board of Works and Safety.
Which we've given you. That's what we gave you before we reconvened. The SOPs were just given to you before.
I didn't ask for SOPs. I asked for all rules for government and discipline of police adopted by the Board of Works. I appreciate that the Board of Works attorney wants to testify that the SOPs are all rules for government and discipline of police adopted by the Board of Works and Safety.
Not trying to testify, Mr. Butler.
But
I'm just stating that those are what we are presenting to you as...
Those are what you're presenting.
No, that was actually by the chief.
I don't care who presented it. My point is, your official record keeper is the clerk. And I've asked I don't know what rules for government and discipline of police you've all adopted. Your predecessors adopted. Your predecessors before that adopted. I don't know, but we've asked for that. That's what we've been talking about. We asked for all general and special orders to the police adopted by the Board of Works and Safety. We've asked for minutes of all those things. We've asked for DVDs of meetings. Frankly, we don't need them if we've got the minutes. And you know, that just takes us up to item 10. There are 48 other items. If we want to sit here and go through item by item, that's fine. But again, at the end of the day, not to be difficult, we're entitled to subpoena witnesses. We properly subpoenaed the witnesses. She's refused to appear. She's refused to produce books or papers. And we need her. And I think we have a right, I know we have a right to call her. I think we have a right to present our case. And we can't because she hasn't complied with your subpoena. And so I've got the motion. Either you're going to let him call his witnesses or not.
Donnie said one there. Bill.
Somebody call it. Suzanne?
Suzanne, you got a phone on?
Take a short recess.
Take a short recess till she can hold Jackie.
I called her during the break and said, we'll see.
Well, it's
on those days.
Been busy? Have you been busy?
Lately, yeah.
Here or elsewhere? Jeremy County?
No, actually not. It's been, oh, I just came from Columbus. And I've been in Still. I don't know.
So you go all over there?
Yeah.
Technology is doing very well in that field. Well, that's what I was talking about. If I should.
Yeah. How long was it? Theoretically, I guess you can.
Is this a regular meeting?
Well, I write shorthand, but it comes up great.
But you couldn't just print it out and let me know.
It wouldn't be very, I mean, you know, because I have to designate each speaker. And so it's not translated. Yeah.
That would be a
Let's see, I started here in 2002, so that's what, 11 years?
For the possibility.
And then I worked 10 years before that. And then 4 years before that. Yeah, so, and I was living not on purpose.
Enough. There's somebody that says no more bond. They knocked out in it down.
Not as good.
I still think taxes are Don't whine, everybody. I used to run the youth center. What's right house? Right back there. Yeah, yeah. The old house. That's right. What are you doing now, Kim? Oh, that's a, I look at you.
Yeah.
What are they doing? Put that in your head. They would know. Well, last time I was on Facebook, we were hired this weekend right now at a hotel. I think that's. Oh, well.
Come on. Getting there? Sleepy? Yeah.
Are you sure that
Pretty cold. Well, it says it's up to 75 now, and it's actually set on 75.
I agree.
It's on a timer.
Yeah.
So it went back up to 75. So we're not- Thank you. These wool coats and neckties are killers.
Calling me at like 2 o'clock in the morning.
Constitutional rights.
Yeah, we know that.
Ready? Back in session.
I guess if, Mr. Butler, you first requested a recess because Jackie wasn't here, and there are certain records that she didn't produce. Is that, without elaborating further, is that your basic request?
Well, yeah, and I made that motion to get your assistance to get her here. But again, if we can just do it cooperatively, I'm fine.
So, the board, I've talked to you all independently, but I think with it being your decision, I think we need to hear from each member of the board as far as to this request for recess based on Jackie Stead's not being here. And, well, I think that everyone would have been okay if all the records were produced according to the subpoena of 48 items. But because not all of those items had been produced before the state, he's requesting that she be here. So I'd like to hear from the board on that, please.
Aaron?
As I discussed with Leslie in the back, I wasn't concerned as much without her being with her not being here, but I was concerned that all the documents weren't here.
Bill?
I guess we're gonna recess until we can get Jackie here and get the documents delivered.
Mr. Bryant?
Yeah, I'll go along with recess until Jackie's here and the records are here.
Okay. Before we do recess on this pre-hearing entry, I realize I think I put the 11th, and we can redo this when we come back, but I do think that the public meeting was originally set for the 10th because Mr. Diltz had a conflict on the 11th.
Yeah, and I said earlier that I thought for sure it was the 11th, and I was wrong. I just consulted my calendar, and it was in fact the 10th, and the entry was right the first time. It was my mistake.
I'm not sure what you're saying. Which the decision will be, perhaps?
That was the day we were going to pronounce the sentence. I think the board, according to, and we'll do a vote here, but I think the 10th would be a good time to reset this since all parties are already.
What day of the week is that?
That's a Tuesday.
I'll make it.
So I guess we need a vote from the board.
Got a time?
What time, 4 o'clock?
4 o'clock.
Leslie, one caveat, and I don't have my calendar. As long as I don't have a Greendale meeting that night, I've got my daughter, but I'll get a sitter. But Greendale gives me a check every month, and I'm required to be at those meetings, so that'd be my only problem, and I'll make any time work.
When we call Hedrick, make sure you don't have a meeting?
That'd be fine. A little embarrassing. If I had my calendar, I'd know, but
What's, need a motion for the board? September 10th, 13, 4 o'clock.
So move.
All in favor?
Aye.
All against? Ayes have it. When do you let us know?
first thing.
Okay.
I'll just call Leslie if that's all right, Mr. Mayor.
Recess this hearing until September the 10th at 4 o'clock.
Toby.
You sure? Hey, Pat.
I just want to make sure.
Pat. Dave.
Well, that's what I'm saying, I just want to make sure. And if it is, then thank you very much. If it's not, I understand. I'll just hand it back to you. Jeremy, have a safe trip home.
Thank you. No, it's just, I'll probably sweat a lot.
Can I get your name,
less
please?
in my car.
Suzanne, S-U-Z-A-N-N-E.
Am I the only one that thought it was?
No, the last name is really O-R-N-B-O-R-F.
It's all full of it at the next meeting. So it'll be first and third Mondays and one's on third Monday.
Am I taking these, or are you going to keep these?
How much time you got? Okay.
No, I
already answered, so there's no problem.
No.
As far as the fees,
No, I didn't put Jack out.
so, well, let me get it out.
She's got.
That is my calculation.
And I'm going to be in.
Call 532-3500.
It should be,
Tell me when you're on the agenda for the second council meeting in
I can do
September.
my email. And I'm sure it's probably fine.
okay. I think we talked
It's
about
public,
it.
you know when those meetings are.
I think we talked about it at our hearing, or our conference call.
Yeah, so maybe that's probably fine.
Okay.
Do you want me to put the next meeting in my calendar?
Yes.
You got 2 hours.
It was September.
September
Take care.
10th
Good
at
to
4
see you.
o'clock.
Thanks for being kind to me. Hopefully my brain's being.
Go ahead and say, thank you both very much, and we'll get your name down. Thank you. Tell her thank you too.
Hey, will you go tell them to listen? They can go.
She what?
Hey, tell them all about it. You know who they are. You can go to the road, you can go.
She's gonna be on track, right, or she points? They're not gonna be.
Yeah. Jenny?
I do. Yes. Yes, I do.
Making sure, you're confused with any other.
Next week.
No, I do. I actually do.
But, I mean, we're out Monday too, so I figured we could do Tuesday or Wednesday, but I think I took that bill with you last time.
Really? Your phone's on? You can't be sure.
I had it out in the car.
I told you, you told us this was 3 years ago. I told you.
Let's go for a couple of
Yeah, I mean, if you said it's on Tuesday, you know what?
Thank you.
Is that next Tuesday? Maybe the Friday before? Friday before? Okay.
I don't know how to turn it off.
Huh?
I don't know how to turn it off.
I told him to put a toggle switch on that thing, on, off.
On, off.
It's gotta be,